Hi. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In indictment 22 SC 183572. All right, Mr. Stillwell, Mr. Boston, Mr. Sharp. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Nard. Good morning, councils. All right, Mr. Kendrick and Mr. Weinstein. Good morning. All right, Mr. Huey, Mr. Matthews Jr. Good morning, sir. All right, Mr. Nichols and Mr. Harvey. Good morning. Mr. Garner. Good morning. All right. Mr. Ryan and Miss Abbasi. Good morning. How are you? All right, great. All right, Mr. Smith, Mr. Uhelski, Mr. Atkins, ladies, Miss Hilton and Miss Love. Good morning. Miss Randolph? Who's your Miss Knight? Miss Knight? Good morning, ma'am. How are you? All right. Okay. All right. Mr. Steele, what is the name of your most able assistant for the summer? Pronounce your name phonetically for me so I can get it.
It's Halterwinger.
Halterwinger?
Yes.
H-A-L-T-I.
W-A-N-S-N-S-H-E-R.
Okay, Halterwinger? I think I got it now. All right, okay. Okay. All right, Mr. Kokomo, good morning, sir. All right. Anybody else? We forget any other assistants? All right, okay. All right, I am in possession of the correspondence between Mr. Steele and the rest of you, which I'll mark as the next court's exhibits in order. And I'll hear entertain brief argument on the issue of the admissibility of Mr. Winfrey's indictment, which the court has been given a copy of. The redacted indictment, is that correct?
Yes.
Okay, all right. Tell me to begin with, State, why are you seeking to, you're going to ask Agent Racy about it? Is that correct?
We are.
Okay, and what is the purpose of admitting the indictment?
Let me be clearer. While Agent Racy is on the stand, the state intends to introduce the so with the understanding that there is a redaction, but we will put into evidence the actual certified copy of the conviction for Jimmy Winfrey. We will be using, for these purposes, the redacted copy with the agreement and consent of counsel for that aspect of it, and not the full.
I apologize, Ms. Love. I'm so sorry to interrupt Ms. Love. I don't know who did consent to this. I did not, Your Honor, so I don't want.
Okay, and that's fine.
So,
I just want to know, what are you seeking to ask Agent Racy about?
other than the fact that, other than introducing the certified, we didn't intend to question him about the indictment at all.
Okay, because ordinarily, courts limit the examination of a witness about prior crimes to nature of the crime, date, and the sentence of the punishment. So,
And in this particular case, Your Honor, to be certain, we are not doing that, delving into who was, all of that. We're introducing the certified copy of his conviction for this particular indictment and these particular offenses, and that's it. That's it.
okay.
We won't be questioning Agent Racy about it. So we won't be saying,
She's not planning on getting into any of the details or
Correct.
anything such as that.
correct. We're just introducing, and when I said with the consent of the parties, what I mean is I'm certain that there has been an objection to the certified as it is. So we had to redact the certified and provide the court with a copy of the redacted certified that we will be using in its stead. So unless I'm incorrect in that respect, that aspect of it is what parties wish to have occurred, considering their objection to it overall, I guess. But we would be using the redacted copy of the certified instead of the actual certified, unredacted copy.
Okay.
I know that.
Okay, is it, okay, so assuming you're just gonna ask this and over objection, if it's in proper form and the court allows it, is there any other purpose that you are attempting to introduce this certified copy of this? Because ordinarily, it's limited as to what is admitted and what goes back with a jury. So that's the other aspect.
Well, the what goes back to the jury part of it, we weren't even addressing yet. And with the court's permission, we would like to address that at a later time as it gets closer to that point. But as to what is being admitted now, we're just tendering the copy, the redacted copy of the certified.
Okay.
And we'll label, I guess we'll label the original as one exhibit number and the redacted copy as the original number sub alpha. Oh, and I'm sorry, Judge, Ms. Hilton has just reminded me, the court inquiry may have to do with why we're bringing it in, and it's part of the proof of this overt act.
Okay, well, if that's the case, then there's a little bit more detail that goes into it as to and I have to apply a 403 balancing test as to this. So,
And Ms. Hilton is reminding me that we have put it in the indictment, and all of the overt acts that contain a conviction, we've put those in the indictment, so it's not.
okay, all right. So but this is already fairly contained within the current indictment that we are trying at this point in time.
Yes.
And that being indictment 22 SC 183572.
The offenses alleged, yes.
Okay, all right. Okay, Mr. Sharp?
Well, I was going to try to draw the court's attention to what the state wasn't providing, which Ms. Hilton, I guess, reminded Ms. Love of. The purpose that they're admitting this, I just want to remind the court, typically when we're dealing with convictions, typically certified convictions, it's for impeachment purposes. Mr. Winfrey is not testifying in this case, as far as anyone knows. So this is not a matter of impeachment. They are bringing this in as, attempting to bring this in as substantive evidence of, and when they say it's included in the indictment, they're talking about the overt act involved is alleged in the indictment. There's not reference in the indictment to Mr. Winfrey pled or anything like that. They're just charged the overt act. So essentially they're trying to use this certified conviction as substantive evidence of somehow our guilt for this overt act. When I say our, I'm talking about people other than Jimmy Winfrey. And I'm just confused because the state is saying, oh, we're just trying to get this conviction in. Oh, well, you know, we'll deal with whether it goes back with the jury at a later time. And they're really burying the lead here. They are seeking to admit a conviction that, quite frankly, is a speaking indictment and has a lot of allegations and factual allegations printed on a piece of paper. And of course, they're going to want it to go back to the jury eventually. They're going to want the jury to read that indictment, read that Jimmy Winfrey pled guilty, which is in fact not true.
Well, he pled no.
He pled Alford.
He pled guilty under Alford.
Well, and Your Honor,
and an Alford plea is a form of a guilty plea, and it's recorded as such.
well, Your Honor, that's respectfully.
And I took a look at the case law, and I'll respectfully disagree with you. It's still a conviction.
Did you look at Doe, Liebsch? And I think one of my colleagues is planning on arguing this, but I'm just going to bring it to Your Honor's attention. It was shared with me. It's a Minnesota case, but I think Your Honor was on the right track when you talked about 403.
Yeah, I mean, it's a conviction that's under 10 years old, but it, you know, there's a presumption of prejudice, and but the court has to weigh certain factors. There's about 5 factors that I weigh, and one of the factors I weigh is the similarity between that particular case and this case in terms of what is being sought to be proven in this case. So what the state, I assume, is alleging is that they, you know, that given the fact that gang involvement and some other predicate things that they bear the burden for, that is relevant for that purpose.
Well, respectfully, Your Honor, the 10-year rule and all that.
But it's not 10 years old yet.
It goes to impeachment. That's to its value as impeachment. That's under the impeachment rules. Jimmy Winfrey is not testifying. So this isn't a matter of impeachment by form of conviction.
Okay, all right. So stop. I want to pause you just a second. What's the state have to say about the fact that this is not being used for impeachment? You're trying to introduce it in your case in chief. The witness is not testifying.
Yes.
What's your theory of introduction?
That RICO is properly established by prior convictions, Your Honor, as the an individual violator.
For a case that you're going to cite me for that particular proposition now?
Yes. So, and
All right, let me see it. Let me look at it.
okay, is the court waiting on me?
Yeah.
Okay, so Your Honor, I'd cite United States versus Pelulo, P-E-L-U-L.
U.S. I'm sorry, I won't move to this. Give me a second. What's the name of the spelling? P?
E-L-U-L-L-O. 14 F third, 8.
Was it decided on the 20th of March of last year?
No, Your Honor.
Okay, all right, give me the citation then.
14 F third, 881 at Penn site 888.
You said 14 F third.
Yes, Your Honor. 881 at page 888. For the proposition that prior convictions are routinely admitted into evidence at subsequent RICO trials. What? Where the court says, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder, who can accept or reject such evidence as it deems appropriate. Also see, when the court is ready, I'll cite the next case. You're talking about starting at specifically.
Because it looks like the district court,
888, inside 888.
you said 88838, is that it?
Yes, Your Honor. In the next
Hold
case,
on. Okay. I'm citing from that decision, 14 after 881. Who argues that although the conduct underlying the prior conviction may serve as a predicate act in a subsequent RICO prosecution, there's no legal authority the government may present evidence of actual judgment of conviction from previous jury trial in the same indictment. The essence of this position is that it's too prejudicial to the defendant to admit this evidence because the judgment of the conviction comes from the same indictment as the jury presented as before it for resolution. In effect, it's an argument in the 403 of the federal evidence. So in the Lulo, the judge didn't do the balancing test. And that's what caused the appellate court to remand it back. So that's my reading.
and so, Your Honor, to continue with that, the government may introduce evidence of prior convictions to establish a commission of predicate acts and a RICO prosecution that the court would see United States versus Tocco, T-O-C-C-O, 200.
C-O-C-C-O?
Yes, Your Honor.
What is it?
200 F 3rd 401 at Penn site 417
Okay.
through 418. And in that, Your Honor, as the court is looking that up, I'll just say briefly.
Oh, I can't read this. You're not gonna do one thing or the other, okay? I can read and
That's
do
fair.
this, or I can listen to you, but just
Read it.
give me a second, okay? All right, I've read, pin site 417. So you're saying a plea agreement can be used to attack witness credibility? Is that what you're indicating?
Your Honor, the district court's admission of a co-defendant's prior conviction was permissible to establish RICO predicates because the evidence was not used as collateral estoppel. That's the portion.
Where is that?
It is just one second.
I see it now. I see it now. Toko, I'm quoting from United States versus Toko, and that's 200 F 3rd 401. Toko argues that the government is not permitted to rely on the judgments of conviction to prove the predicate acts of a RICO charge. Such use of those convictions, he claims, institutes improper offensive collateral estoppel, relying on the reasoning in United States versus Ural, 14 F 3rd 881, Third Circuit, 1994. In Palulo, however, the district court held that the previous conviction of a defendant established the existence of a predicate act under RICO, and the court instructed the jury to recognize that predicate act as a matter of law. See Palulo 14 F 3rd at 889, pin site 889 to 890. The instant case is different because the district court here entered into evidence the convictions of Toko's co-defendants, who had the opportunity to show the jury that he was not involved in the crimes. Furthermore, the court did not give a collateral estoppel instruction as the court did in Palulo. The government explained that whether or not Mr. Toko was connected to that is a jury question for the jury to determine. Also, there was other evidence that corroborated the information about the convictions in question. Thus, because no collateral estoppel effect was given The challenge evidence, Choco's argument is unfounded.
And Your Honor, further, the 11th Circuit in United States versus Gonzalez at 921 F second 1530, pen sites 1535 through 1539. In analyzing the United States Supreme Court case of Garrett versus the United States, which I'll give a cite for,
Let me have the Gonzalez site. How do you spell Gonzalez again?
Gonzalez.
And the site is what? This is the 11th Circuit case.
It is 921 F second 1530. And a pen site when the court is ready.
You said 1530?
Yes, Your Honor. The Division 2 Art Gonzalez at pen site 1535 through 1539.
1535.
Yes.
So which 1535 to what now?
Through 1539.
All right.
And it just addresses another argument made in opposition to prior convictions forming the basis of RICO predicate.
Where in there does it address that? Because you've got a lot of flags, you got a lot of red flags within that section. So which one are you referring to?
Where the court found no violation of the double jeopardy clause for prior convictions form the basis of RICO predicate acts in the subsequent prosecution. That is specifically that.
Your Honor, I don't believe any of our arguments are based on double jeopardy at this exact moment.
And with respect, the purpose of giving these case sites to the court is to show the permissibility of using a certified copy of Jimmy Winfrey's conviction for this event, this predicate act that is in our indictment. So it's to show that there is legal support.
Okay,
for that.
all right.
Also, Judge, United States versus Sparka. SCARPA 9.
Spell the last name, please, again, madam.
It
Sparka.
is Sierra, Charlie, Alpha, Romeo, Papa, Alpha.
And the citation is, is it 861 F 3rd 59, or is it?
It's 913 F second, 993.
You said 913 F 2nd?
Yes, 993. At pin site 1013 through 1014.
All right, let me get that, please.
And
Hold on, let me get that, please. Scarpa looks like was overruled by another case.
Another ground.
Okay, so what is the,
It essentially is echoing what the court found in the previous case in Gonzalez.
and Scarpa, what do you ask me, what pin set you asked me to look at?
1013 through 1014.
All right. All right, this deals with basically the strike portions of the indictment. Court in Scarpa disagrees. Motion to strike surpluses from an indictment will be granted only where the challenge allegations are not relevant to crime or inflammatory or prejudicial. And they cite United States versus Napoleano, 552 F sub 563 580, Southern District of New York, 1982. It says evidence of an allegation is admissible and relevant to the charge, and regardless of how prejudicial language is, it may not be strict. United States versus Palma, and that's 561 F sub 778 and 797. That's the Southern District of New York case, that 1978. RICO cases, courts refuse to strike allegations of organized crime connections that serve to identify the enterprise and the means by which its members and associates conduct various criminal activities. Now, the court will note that there is an overruling risk for Napoleano in Illinois versus Gates, which was decided June 8th of 1983. Are you certain that none of those will affect this? Is that, what other grounds are you talking about?
In particular within Scarpa, where the court cites United States versus Persico, PERSICO, at 774 F second 30, and cite 32, that portion.
Your Honor, may I be heard? It's like the state just put in RICO and indictment, and they're just giving you a bunch of cases. These cases have nothing to do with our argument.
Well, that's your assertion, sir.
Well, it is my assertion. It is a correct assertion.
And you're sir. Sir, let me just tell you, if you could take down the rhetoric just a little bit. I mean, I can hear you. I'm gonna listen to you. You may disagree, but attitude's everything. Okay? I'm just telling you that.
Our argument is based on the Confrontation Clause. Crawford was a seminal case for the Confrontation Clause. It changed the way we analyze the Confrontation Clause. That's from 2004. They are citing cases from the 80s, which are pre-Crawford and also have nothing to do with the Confrontation Clause. The bottom line, Your Honor, is there's a case, Jefferson, that is directly on point.
And what is Jefferson?
State v. Jefferson. It's from.
Oh, is that one of the cases Mr. Steele cited?
Yes. It's
okay, I have it.
It's from this state. It's 2017. It's post Crawford, and it's directly on point. And well, I'll leave it at that. But if we have to go further, there's other differences between our situation here with Mr. Winfrey giving an offered plea, which is not an admission. And I can cite cases.
But it's still a guilty admission or not? It's still a guilty.
Well, I don't want to sidetrack because I think we should stay focused on Jefferson. But I do have cases that address 403 balancing of an offered plea as well. But we can get to that later if we need to. But State v. Jefferson is directly on point.
Your Honor, I think that Jefferson is quite distinguishable in that in Jefferson,
Doesn't the state allow
I'm sorry, am I
His
allowed to
Honor.
speak yet?
Right,
read the case?
I can't, what you just said is not on the record. Speaking at the same time.
Just give me a minute. I've considered Jefferson already, so let me just circle back. Okay. I had a chance to relook, Jefferson. Jefferson cites some, Jefferson cites some fairly old law, but, Kirby, back in 1889, but basically it says that an attempt by the United States to introduce certified copies of conviction for three individuals for theft of government property as evidence, and prosecuting Kirby for being receipt of stolen property is improper, as that introduction of such evidence violated Kirby's Sixth Amendment rights. It looks like under Jefferson, that 1659 was that they asked our appellate court to have it declared unconstitutional. Also, but I was going to ask you, has it been updated since then? But I've taken a look at it, but it seems to be that Jefferson indicates, as shown above, the United States Supreme Court's decision in Kirby is controlling this case, and the Supreme Court has not abandoned its prior holding in Kirby in the 100+ years since it's decided. See Crawford, Supra 541 U.S. at 64, Melendez Diaz Supra 557 U.S. at 314, citing Kirby with approval, and Davis Supra 547 U.S. at 825, subsections 3A. To the contrary, High Court has consistently reaffirmed this holding in Kirby, and the continued viability and importance of that case is made only evident by the circumstances created by OCGA 1615-9. Because 1659 on its face deprives criminal defendants of the fundamental right of confrontation in violation of the Sixth Amendment to the Constitution, U.S. Constitution, statute cannot pass constitutional muster and must be declared void to the extent that it authorized the admission of convictions of non-testifying parties as evidence of criminal street gang. So it cites our Constitution, Georgia Constitution, 1983, Article 1, Section 2, Paragraph 5. So it would appear to me, Ms. Love and Mr. Yahowski, that if Jimmy Winfrey testifies, that's one thing. If he doesn't testify, it'd be by Jefferson tells me that you don't get to introduce the.
So Mr. Lally and the Commonwealth can take whatever position they want to. If they think those injuries are consistent with being hit by a 6,000-pound truck, they can knock themselves out. That is not the state of the case, and they don't get to dictate the state of the facts. The facts speak for themselves. Second, with regard to whether or not Mr. Albert was home that night, or at the home that night in a position to be able to engage in a physical altercation, which, by the way, takes about that long, that is predicated on his own family members covering for him. Every one of the witnesses who testified basically are friends and families of the Alberts. And keep in mind, Your Honor, I don't think it's lost on anybody that Colin Albert was hidden, specifically and intentionally hidden from all of law enforcement for the first several months of this investigation. Nobody was willing to even say he was at the house. That is highly, highly suspicious. Given the gravity of what we have now, I would take an issue with one thing Mr. Lally said. He said this diverts the jurors' attention. I would agree it diverts their attention. It diverts their attention to somebody who possibly could be involved with this, who was not properly investigated. And I'll submit.
Okay, so may I have those 2 flash drives, please? Yes, no, I was asking them. All right, so why don't we take a 15-minute recess? I'll look at these and then we'll come out.
Court, all right.
at 443. As the court explained, convictions of third-party gang members that are used to show an underlying element of another defendant's crime are among the types of plainly testimonial statements that cannot be admitted in evidence without running afoul of Sixth Amendment protections, where the defendant has not had a prior opportunity to conduct cross-examination of the witness and the witness unavailable. Accordingly, the trial court's finding that prior convictions of one defendant are inadmissible against the remaining co-defendants represents a faithful application of Jefferson. So we affirm that portion of the trial court's ruling. We cannot, however, affirm the remaining portion of the trial court's ruling, namely that the defendant's own prior convictions are inadmissible against the same defendant at appellee's joint trial, as that ruling rests exclusively on an overly broad reading of Jefferson, a reading that is contradicted both by Jefferson itself as well as by subsequent decisions of our Supreme Court. See it at 442, note 6, 807 Southeast 2nd, 387. Indeed, the Supreme Court has repeatedly emphasized the limited scope of Jefferson's holding. Jefferson operates to exclude evidence that third-party gang members have committed any of the offenses enumerated in the statute 1615-3 for use as proof against a particular defendant. Anthony versus the state, 303 Georgia, 399, pinpoint 409, 8, note 16, 811 Southeast 2nd, 399, 2018. And our Supreme Court has been quite clear that Jefferson is not implicated where a defendant objects to the admission of evidence of his own criminal activity and not the criminal activity of third-party gang members. So
there you go. So that therein is the difference. That's where this is a different case because it's a RICO. The acts of one, whether they result in convictions or not, are properly imputed to the members of the conspiracy as found by the jury. So Jefferson being a limited holding, it's not a RICO case. It's about a gang count. And the discussion is relevant, but it's just one piece. That's why we revert to this federal authority that says routinely prior convictions are used as substantive evidence. That's the issue right here. Can this come in as substantive? Now, whether, Your Honor, later on, we have a jury instruction under 105 that says, hey, this conviction is admissible against Winfrey, who is still a party to this case, although he's not sitting at any table, that could be used as proof of a predicate. That's the federal authority we cited. And then the testimonial aspect, if we are admitting proof of a predicate act, in this case, over Act 39, we're admitting it against Winfrey, but if the jury by other evidence says, yeah, we think Winfrey did this, I mean, and they're free under that discussion of collateral estoppel, they're free to disregard the conviction, and they actually could be properly instructed on that at the end of the day. But if they think the conviction, as well as all the other evidence, including Alvin Lewis, Detective Racy, et cetera, does add up to a
looks like
conspiracy.
here, Thomas says, therefore, the trial court views its discretion by relying on Jefferson to exclude evidence of a defendant's own prior convictions for use against that same defendant in a joint trial. So we reverse that part of this ruling and remand.
Yeah, it was abuse of discretion to exclude the conviction, not to admit it.
Exclude the conviction of the defendant that was on trial. Thomas.
Doesn't say that.
We should have cited Thomas, and I apologize because Thomas reaffirms Jefferson, which is that third-party convictions should not be admitted. And the state is arguing, well, it's admissible against Jimmy Winfrey. Jimmy Winfrey's not sitting here. So if they want to present evidence that's admissible against Jimmy Winfrey, it's wholly irrelevant. It's wholly irrelevant. It fails 401 because he's not sitting. It's 403, of course. But Thomas just reaffirms what we're saying in Jefferson. Your Honor, you're right on it. What you read was exactly the point. The third-party convictions of Jimmy Winfrey, who's not on trial, admitting those would be a constitutional error in if Jimmy Winfrey were sitting here at trial with us, perhaps the state would have a better argument. I would still have issues with it, of course, but perhaps they would have a better argument. He's not sitting here. What they're trying to do is clearly in violation of the Sixth Amendment, clearly in violation of the Confrontation Clause, clearly in violation of Jefferson, and clearly in violation of Thomas. And it needs to be stopped now.
So Winfrey's not a third party, Judge. He's a co-indictee under count one.
These people in these cases were co-indictees. And on trial.
But I think Your Honor gets the gist of
But he's
Tom.
still a defendant, Mr. Sharp. That's the problem. For you. And I respectfully disagree. I mean, the fact that he's not here sitting here, he's still a defendant.
But in all these cases, in Jefferson, in all these cases, people are defendants, they're severed out, it's no different in Winfrey. And the state's reliance on cases, they keep going back to cases that, again, I serve, do not say what the state's claiming they say and do not address our Sixth Amendment arguments, but also they're pre-Crawford. They're useless at this point. Crawford was 2004.
I have some recent Georgia authority on that point, Your Honor, if you'd like to delve in.
But it looks like Judge Pipkin and Thomas says, we emphasize our holding here is confined to the narrow issue of whether Jefferson requires the wholesale exclusion of appellee's prior conviction. While there may be good reason to exclude evidence of one defendant's own prior convictions for use against the same defendant at appellee's joint trial, we conclude only that Jefferson does not supply such a reason. And because our holding here is limited, this decision should not be read to express any opinion concerning whether the evidence of the prior convictions should ultimately be excluded, a question which is reserved, at least in the first instance, to the trial court in its sound discretion. So it looks like that Thomas is indicating and Judge Pipkin is indicating that they're not willing to go that far that a defendant's own prior convictions are inadmissible against that same defendant in appellee's joint trial. They would indicate to the court that they are admissible, defendant's own prior convictions. So thus Mr. Winfrey's conviction in Cobb would be admissible against him here in Fulton.
He's not on trial, so it has no applicability in this case, no relevance to Mr. Winfrey's conviction in this case. If it's admissible against Mr. Winfrey, even if I concede it's admissible against Mr. Winfrey, he is not on trial, so it has no relevance to the guilt of these individuals because Thomas and Jefferson make it clear it's not admissible and should not be considered against any of these gentlemen. And that's so it would just fail 401 relevance and 403 balancing.
Can I refer Your Honor to one additional case, please?
Can you turn your mic on so I can hear you?
Yeah, I guess
Judge, can I refer you to a post-Crawford case regarding specifically a co-defendant's plea allocution?
Okay.
That's United States versus Bruno, 383 Fed Third 65.
383 Fed Third what?
65. United States versus Bruno, Bruno.
Okay, and what does Bruno indicate?
That the plea and plea colloquy of a non-testifying co-defendant violates the confrontation clause post Crawford.
Give me about 5 minutes, okay? All right, we're gonna recess. All right, Ms. Love, are you rising to say something, madam?
Yes, Your Honor,
Okay.
just that the state will not introduce that document today, and we're withdrawing our efforts to do so.
So you're not going to have Detective, I'm not Detective, Agent Racy cover it at this point in time?
Correct.
Okay, all right. All right, well, and that resolves my issue of having a rule on it then at this point in time. So, okay, all right. Anything else?
I understood that the state was
I also understood that the state was moving, I think today, I'm not sure, depending upon the length of the cross and redirect. The CAD reports about some of the other incidents that were not prosecuted or may have been prosecuted, is that today?
It could be, if I may address the court, it could be today, Your Honor, but it won't be with this witness. And I believe that there will likely be a significant amount of time before we actually get into that. So I don't think that that is something that we should delay.
Okay, I mean, that's fine. I just want to,
Proceedings for.
there's an issue with regard to those that I'm going to have. So before the introduction of those, and I know the witness that's coming, Miss Latner, right?
Ms. Latner's?
Yes. So before she comes on, I'd like to address that, please. Thank you.
Okay, all right, we can hold that until a little bit later, until before Ms. Latner's rejoins us. And, okay, all right, anything else? If not, let's go ahead and summon our witness, please, Agent Racy. And then go ahead and, Sergeant Ham, if you could, so I promoted you again. If you could go ahead and get our jurors ready, sir. Hey, good morning. As long as it doesn't involve our witness here, he's already, okay, what's your question, sir?
There is a professional among us. She works with the Honorable Lawrence Zimmerman. Her name is Rebecca, R-E-B-E-C-C-A, P-A-R-A-P-I-S.
Why are you bringing up Lawrence Zimmerman?
Because I love Lawrence.
I don't. He's got a terrible tie on. He's always, pontificating and whatever the like. Mr. Zimmerman, you're always welcome as a public spectator. Good welcome, sir. Yeah. All right.
Co-worker has been helping. I just want to know if it's okay at the proper time to sit with us. And I asked the sheriff, he said that as long as it's okay with the court, he will,
As long as you can get space allocations, that's fine. Okay. Is a jury? Okay, all right. Anything else before I bring in our jurors? Okay, all right. Summon our jurors, please, sir. Hey, Chris, I'm gonna give you this back. Yeah, so I don't lose it. It may have been marked as an exhibit anyways. Ladies and gentlemen, please be seated. All jurors are present, sir? Okay, thank you, sir. All right, ladies and gentlemen of the jury, good morning. Good morning. All right, sorry for the delay. It took a little bit longer to take up our business this morning, so we appreciate your patience in that respect. Agent Racy, good morning again, sir, and just a reminder you're under oath. And Ms. Hilton, you may continue, madam.
Your Honor, I believe it's
Mr. Steele, I'm sorry, Mr. Steele, you may continue your examination.
Good morning, Your Honor. Thank you so much. Good morning, Agent.
Good morning, sir.
Good morning, Mr. Steele. All right. I believe yesterday we stopped, we were talking about if I could just refresh your memory. And if I leave something out, just tell me, but I believe we were at Brian Williams' phone. That's what I remember. Or the phone that we, through your investigation, attributed to Mr. Brian or Birdman Williams. Is that okay? Yes, sir. All right. So I'd like to discuss that. And just for the jurors' edification, that should be the number 2920. Is that accurate?
I thought we were doing that 8553 was the number.
8553. I have that as Jeffrey Williams' purported phone.
Yes, is that what you were asking? I'm sorry.
No, I'm going to, yes, we'll use those records.
Yes, okay, yes.
I see what you're saying. Yes,
Okay.
we will use the records, and I think it's on the screen already. Let me get the exhibit number. That should be exhibit number 137E, Your Honor, and it's displayed. Is that okay, Your Honor?
Yes, sir.
Okay, it's already admitted. All right. On those records now, I'd like to talk about the gentleman known as Brian Williams or Birdman. Is that okay?
Yes, sir.
And through your investigation, did you look into that gentleman's background?
What do you mean by background?
What he does for a living, his occupation?
I know his occupation, yes.
Okay, tell the jurors if you don't mind.
I mean, he was a music artist and then at least owned Cash Money Records. I guess it would be a manager or producer. I don't know the exact title at that point in time, but he certainly owned that and then had artists signed underneath his label.
Okay. And those artists include people that you've discussed in this case?
Some of them have been discussed in this case. At least one of them has been discussed in this case.
And tell the jurors who that one is.
So under Cash Money Records, there'd be the YMCMB, which is, well, without going into that, it would be Dwayne Carter, Little Wayne would be signed underneath the Cash Money Records through the YMCMB.
Okay. And Birdman Williams, Brian Williams, performer known as Birdman, 2920, correct? Is that?
I believe that is correct, 2920.
Just
Yes,
make
sir.
sure.
I'm sure it is.
Okay, let's talk about those. Using, as you said, Jeffrey Williams records that are in evidence under State's Exhibit number 137E. If you don't mind, let's do a search for how many times that they correspond or connect, I think is the right word, right? Is that true?
I would say just connect, yeah.
Okay. If I can ask Haley to do that search and then you help us. Okay, do you see the number there?
I do. The same issue. It looks like the 1/9, so possibly 9 times throughout the entire document.
Okay, and the jurors probably remember, but just for simplicity, Jeffrey Williams records go from January 1, 2015 to
July 15th, 2015, I believe it was.
So we have 9 contacts, and if you don't mind, we're going to go through those, okay?
Yes, sir.
All right, so the first contact, if Haley can take us to that. You see where it's highlighted, and the jurors, you can help them. That should be item number 1125 or 1125. Is that fair to say?
Agreed. Yes, sir.
And that's January 28, 2015?
It appears so.
And then it's 1905. So you have to do, these are AT&T records. So you have to do the conversion. Is that correct?
-4, yep, sister.
So -4, just do it for them or I could do it, but
Either way. So 19 -4 would be 15. And so converting 15 into Eastern Standard Time, or excuse me, from military time to the 12-hour clock would just be 3:05 p.m.
okay. And that is a 1 second seizure time, meaning as you looked on your cheat sheet or the AT&T codes, that's how long it took for the...
Correct. The dial time would be the seizure time from what we learned and the key. And then the ET would be the time of the actual connection or Yeah, the connection of the phones, whether it be voicemail, whether it be communication through voice, that's just the connection time.
Okay, and in this one, it shows 1 second from the person pressing the send, and then it had 0, so there's no connection. Is that fair to say?
Yes, that appears correct. Yes, sir.
Okay, and just for correctness, that would be Jeffrey, what I'm calling Jeffrey's phone. I understand that, you know, it's a phone that you designate Jeffrey Williams, the 8553, calling the 2920, so calling Mr. Brian Williams' phone. Fair to say?
It appears that way. Yes, sir.
Okay, if we can go to the next one. Okay, and this one is item number 3758, 3758, fair?
Yes.
And again, we're talking about a couple of months later, so we're in March 30th, 2015.
Yes.
And then that one is at 241, if you can do the conversion.
Okay, so -4 again would put us at 22. So that would be 10 p.m. But then you obviously you have to convert it from 2200 into Eastern Standard Time, so it's 10 p.m.
About 10:41, is that fair to say?
Yes,
At night.
10:41. Correct, sir.
And then now we have a 12-second elimination time from the time the person hit the send. It was trying to connect for at least 12 seconds. Is that how the record reads?
Correct. And then the connection 4 seconds. Yes, sir.
And there's a 4-second connection. That again, the way I read it is Jeffrey's phone, the 8553 number, calling Mr. Birdman, Brian Birdman Williams' phone 2920. Is that correct?
That appears correct.
Okay. Then you have, I believe, right under it. Do you see the next line? It's line number 3759.
Yes, sir.
Same date, and it's 7 minutes later. Fair to say?
Fair to say.
And this is a 18-second trying to connect, but no connection. It says 0 conversation.
Fair.
Okay. And then this is the opposite. This is Mr. Brian Williams' phone calling Jeffrey Williams' phone. Fair to say?
Yes.
And for the juror's edification, through your investigations, do you have any evidence that Mr. Brian Williams is related? I say related, I mean blood relation to Mr. Jeffrey Williams.
Yeah, to my knowledge, no familial relation.
Okay. The next contact is right underneath it, 3760, 3760. You see that?
I do.
And we're talking about the exact same date and same time. You see that?
I do.
And then we have the same thing, Mr. Brian Williams, performer known as Birdman, 21-second, his call's trying to get through to Jeffrey Williams' phone. It doesn't connect. Is that okay?
Yes, we see what it did there below it, but yes, it didn't connect.
Okay.
It rolled to voicemail.
Okay, and that's the next number.
Correct. So that's where you see the D and the F. So it forwarded to that number, which is going to be AT&T's probably voicemail number. And then we see that actually on to the right where it's highlighted. Yep. Yep. We see that it says VM. So it's indicating that it rolled to voicemail. So that's what we see with those extra digits there.
You know, this is small print. Can you just point to the jurors what you were just referring to the VM, if you don't mind, behind you on the screen?
So these kind of codes right here, that VM in the middle is voicemail. And that's kind of what we're seeing here. The D is for the number dialed, F is for the call forwarding. And then we see that that is the actual connected number. And that's likely, we could look in the key and we could look in the information, but that's likely going to be just AT&T's rollover to voicemail number. And again, we see that indicates voicemail. We see that it was the number dialed and number forwarded.
And then all that sequence, that is another contact according to the records. That's why we had 9, right?
Yeah, I believe that's correct. Yes, sir.
So they're kind of clustered, but that explains the records.
So, okay, you're talking about the 2920 while we see this cluster here?
Yeah, like the 3, what you're looking at, the items starting at 3758, going through 3.
I see what you're saying. Those are clustered. Yes, sir. I see what you're saying.
So even though it says 9 contacts, you know, the contacts could be right up against each other.
That's correct.
All right. Next one, if you don't mind. The next one goes to actually today, 9 years ago. Is that correct? May 16th?
Yes, sir.
2015. And that's item number 1945. Is that true?
Correct, sir. It looks like we went from the call logs to, I think we went to the text logs here, the SMST.
Mm-hmm.
It looks like we got a different description code there. So this isn't going to be That's why we're not seeing the dial time, seizure time. We're not seeing that. So it looks like we rolled over to another part of the records.
Agent, would you do me a favor, just point all that out to the jurors, if you don't mind, and explain to them, the difference earlier that they've been seeing and what they're seeing now?
So it kind of looks different if you're paying attention, but what we see here under the description, SMS, kind of old school for text message, and then a T on the end. So the description code changed. We no longer see like the dialing time and the connection time. We only see connection time. So that's just going to be the time that the text went through, presumably. But obviously the document just kind of appears different because we rolled over from the part of the document that was doing the call log to now we're into the text log of these records. Is that sufficient, sir?
Yes, sir. Yes, sir. I appreciate it. And then the next one, the ninth one, contact is right underneath it. It's 1946. Is that fair to say?
Yes, sir.
Same time. And it's also Mr. Brian Williams texting Jeffrey Williams' phone. Is that how it reads?
Yes, sir.
So just in summary, we're really talking about contact on January 28th, 2015, and March 30th, 2015, where we can show no real conversation according to these records.
According to these records, that's correct.
Right.
These records.
I'm not saying they don't have contact. I'm saying according to these records.
To these records, yes, sir. On these numbers, yes, sir.
And then we jump to May 16th for 2 texts from Mr. Brian Williams to Jeffrey Williams. That's what we got.
Appears so, sir.
All right. And that should be 9 of 9 according to the screen. Is that fair?
Yes, sir.
All right. I'd like to go and you explain it to the jury, but you went pretty fast. I mean, not fast, but earlier when you were doing your direct examination with the honorable prosecutor, you also gave us insight into a phone that ends in 5979. Do you recall that one?
Yes.
And if you're looking at something, it's no problem, but just tell the jurors what you're looking at so they could follow along if needed.
I'm just trying to find it so I could speak accurately on it. 5979, you said, sir?
If you don't mind.
It's your cross-examination. There we go. Yes, that's going to be State's Exhibit 138 Echo, and then the Echo Alpha and continuing. But yes.
Now, tell the jurors the reason, based upon your investigation, that you sought those records and who they potentially, I understand all the caveats, but who they potentially align with.
Yes, so this is the one that I did just a subpoena for, so did not get location data from these records. And then it's the name associated with it is the YSL Duke name as the registered, the party, the contact name on it.
And that's fine. We could talk about that one. But
You said 5790, correct, sir?
if I did, because we already talked about that other one, right?
Okay.
I was talking about 5979. And if I said it,
5979. Okay, I'm sorry.
yes, and then tell us that code as well. That when I say code, I should have said State's Exhibit number.
Oh, you have more? Okay.
Hey, Your Honor, for clarity, can we have the full number of what number Mr. Steele is referencing?
If you could give us the number, please.
I can absolutely do that. It is 504-723-5979.
Yeah, I don't believe we tendered an exhibit with those phone numbers.
I don't see up here, Mr. Steele. I think,
All right.
unless I don't have all of them, I don't think we have that one.
Okay, well, let's do it this way. Is that number come up in your investigation?
Can I refresh my memory by our
course.
report? Because if it's not here and we haven't talked about it recently, then
Of course. And I'm not telling you I'm right, but it may be around page 13 of your report, if that helps you. And again, it is 5979.
Unless I'm looking in the wrong place, Mr. Steele, I don't see 57 or 59.
5979.
Yes, sir.
It's not on page 13.
I don't see that, sir.
Give me 1 second. Your Honor, may I just have 1 second?
Yes, you can, sir.
Thank you. Okay, I was right near it. Page 68.
68, okay.
You should have known by my
I started questioning myself over here.
oh, don't question yourself.
Page 68.
That was nowhere close to 13.
And what were you saying the last four were, sir? 5979?
5979, that's correct.
Okay, so according to the report, that's going to be a contact number for the account associated with Brian Williams, that 2920. So that name is entered into the subscriber information as a contact number for the Brian Williams 2920 phone. If that gives you.
So just for completeness, I want to run those numbers on Jeffrey Williams' records, which have already been admitted to evidence, okay?
Okay, all right.
Haley, if you can help us and show the jury. And again, Your Honor, we're showing State's Exhibit 137E with the court's permission. It's already in evidence.
Yes, sir.
And did you find that number? I know you said it's associated with Mr. Brian Williams' cash money. Is that what you told the jurors earlier?
It's listed as a contact number for the 2920 account.
Okay. And the 2920 is what we just talked about. That's Mr. Brian Williams or Birdman performing.
That's the number that I had probable cause and got a search warrant for and reference this investigation.
Okay.
So yes, sir.
And I just want to be complete because it has something to do with Mr. Brian Williams. So Haley, I think just run, you could check it. According to Jeffrey Williams' records, tell the jurors whether Jeffrey Williams has any contact with the association number of 5979 of Mr. Brian Williams.
It appears not.
All right. Let's go to, a person who you had through your investigation, a cell number for a gentleman named Shannon Stillwell.
I don't know if we have it in evidence, but I know the name came up in the investigation. Yes, sir.
Can you look at now page 13 if you don't mind?
Page 13.
Tell me if that refreshes your memory.
All right.
And what that number is or numbers are. We're gonna have to spell out those numbers for the jurors too, if they haven't heard them before.
So if I recall correctly, Shannon Stillwell also goes by Shannon Jackson.
Okay. Yeah,
Correct.
sure.
And so that name, I do have a phone number listed. If you don't mind me just for ease, just reading it off.
Yes,
Okay.
please.
404
Just go slow because people are writing.
957 3059 is what we have for Shannon Jackson.
Okay.
And that's just under the name portion of the report.
Okay. Does he have two numbers in your report? And if not,
It looked duplicative. It looked like it was the same number on there twice.
can you just look closer? And if they are different, just read them both. We'll do them both.
So there's a digit change. 404 951 3059, I think would be the other one. So it's same area code, same last four digits. The middle digits have changed.
Okay. And look, I'm not looking at the document right now, so help me.
Yeah.
First number you just read, or the number you just read, can you repeat that number one more time?
404 957-3059.
Okay.
And then the second number is 404-951-3059.
Okay. All right, we're going to search those numbers. Is that okay?
It's your cross-examination, sir.
All right, well, and I appreciate
If
that.
I said no,
You said
would
no?
that matter?
It could matter, actually, knowing me, it could matter. All right, if Haley can run it, the last four digits of the same, or however, you just make it complete. And she's putting in 3059, correct? Is that the number that you just gave us, the last four? For both of those numbers?
That's the last four. It might need to put in more, yeah.
Okay, can you put in more of the numbers?
It looked like it pulled the area code of not the correct phone number.
Does that look like the right number?
It does.
Okay, and how many results on Jeffrey Williams' cell phone records, AT&T, January 1, 2015 through the 15th of July, 2015?
Again, for these records, it shows no contact for these records.
Okay. And then I think there's a second number that we should
was.
try, shouldn't we? Is that just for completeness? So, and that's the 957-3059. Same answer?
Same answer, sir.
All right. Okay. Now, I'd like to go to Mr. Winfrey's cell records, if that's okay with you. And Your Honor, that is already in evidence. I hope. Let me make sure, Your Honor.
133E.
Yes, thank you, sir. All right, sir. And may Haley put it on the screen, Your Honor?
Yes.
Okay. And these are going to not be AT&T records. These are going to be Sprint records. Is that right? Correct?
That's correct, Sprint records.
And with Sprint records, explain to the jurors whether we need to do that conversion or if it's going to come up in Eastern Standard Time.
So Sprint should come back Eastern Standard Time per these records.
Okay.
If I recall correctly.
Perfect. And that's why the records, I assume, look a little different just because it's a different company. Is that?
Different company, different way of analyzing the data, different key, telling you how to analyze the data.
Now, I want to use his records because you made a decision. You didn't, as you walk through this, some of it's dark and you shine lights on it through your investigation, but you got April 1, 2015 records to April 30, 2015 records. Fair to say?
That's fair to say.
And you weren't trying to limit yourself. That's just at that time you were targeting the 25th day of April 2015 going to 26th day of April. So you got that whole month.
Yes. So basically like the investigative strategy is I kind of didn't know what I had at the point. We just learned of Winfrey being a potential suspect, got probable cause on it. I'm targeting a smaller window. Once I start expanding the investigation, I then have justification, like probable cause justification to kind of expand some searches. So yeah, these records for him were very specific to that window of time that I was investigating and looking for.
And just for the jurors' edification, you did not go back. I'm not casting aspersions at all, but you did not go back and get additional records. This is the records we have.
This is the records, correct. This is the records I have. I didn't do a secondary search warrant expanding anything larger on him.
All right. And I just want you to explain to the jurors from this 1 month of April 2015, help them understand how many entries or contacts does Mr. Winfrey have in that 30-day period? And Haley's going to show it on the screen with your permission, but you're looking at the document itself. Is that fair to say?
Yes, there's 97 pages in this document that looks like the complete records, and I'm sure this will be a different format. This will tell us 4,362 is what's highlighted.
Okay, and that's within 30 days. So just quick math, if you can, 4,362 divided by 30. How many calls is that approximately
A day? I'm not a math guy. That's hundreds a day. It'd be safe to say
All right, okay. And these records for that 1 month for Jeffrey's phone, I just want to show them on Jeffrey's phone, what I'm calling Jeffrey's phone, 8553, fair to say?
Yes, sir.
So if Haley runs that search. We get one contact. You see that?
I see the one contact.
She could scroll. Do me a favor, Haley, please show every page. It won't be all that long.
I don't see the control F, like the box that we had on the other set, and maybe it's because Excel searching differently. Okay,
You see that?
yeah, it's only toggling between the two. Yes, sir.
And that's item number, just for the jurors, 4,297. And it is, Mr., you may have to go to the top, but if you know it, if you don't know, don't agree with me. Please don't agree with me. But that should be Mr. Winfrey's phone calling what we're calling Jeffrey's phone. Fair to say? And if you don't know, just say I don't.
That's correct. The left column is calling number. That second to the left, which is the middle for the phone number digits, is the called number. So the number they're attempting, basically that they're connected to. And then the third one is the dialed digits is what Sprint is calling it. So oftentimes they'll be the same, kind of the same thing. Maybe something's forwarded, maybe someone has something like that. So you'll see a difference, but these are the same. So the number dialed is the number that received or connected to, if we want to say it that way.
And the date of that call?
That's going to be April 28th, 2015.
Okay, and the time of that call? And I know it's military, but then make it into.
Yes, that's just 2010, but we don't need to do the conversion. So 2010 is going to be 8:10 p.m. Eastern Standard Time.
And the jurors may remember, otherwise we could show it again if you don't remember, but that corresponds with Jeffrey's records of that 8:10 attempted contact by Mr. Winfrey to Jeffrey. Fair to
I
say?
believe that's correct. Yes, sir.
Okay. And then that is the only contact for 30 days between Mr. Winfrey's phone records, according to this, right?
That's correct, sir.
All right. I'd like to go back to, it just seems easier for me anyway, Jeffrey's phone records, if I may, and that is, Your Honor, number admitted into evidence, states number 137E. Okay, thank you, sir. So on the screen should be, if you can orient yourself, you see that to be Jeffrey's, what we're calling Jeffrey's phone records?
Yes.
All right. And with this, if Haley, if you don't mind putting in for the agent, Mr. Winfrey's contact, I know we did it before, but now I want to be specific, okay? If you could put in his phone number, which ends, for the jurors' edification again, the 3383 number. Fair to say?
Yes, sir.
All right. And you see the 78 contacts?
Yes.
All right. I'd like to go through them. It should not take all that much time, but if you can help the jury understand it, okay? First contact, is it fair to say it's item number 522?
Yes.
And that's on January 9th of 2015?
Yes.
And we got conversions here, right? For Eastern Standard Time?
That's correct.
All right. So I'm going to ignore the conversions for now on this exercise because
Thank you.
You're welcome. Thank you. But the jurors will know that if they want to look at these records, they will have to subtract the 4 hours. Fair to say?
Yes, sir.
So just for the first one, you would say that's 311 contact?
Correct.
Subtract 4 hours, it would be 11:11 at night?
Correct.
All right. Okay. And that is Mr. Winfrey calling Mr. Jeffrey Williams. Fair to say?
Yes.
All right. And that with no connection. You see the 000?
I do.
All right. And then the next one is the same date at the same time, but another call, Mr. Winfrey not connecting with Jeffrey Williams. Is that fair to say?
Yes.
All right. Let's go. Let's go to the next one. That's number 3. Same date, same time. You see the top is 5:24.
I do.
And again, you have Mr. Winfrey calling Jeffrey Williams, and you explain the voicemail. You see that in the line to the right?
Yep, the feature, under features tab, we see the VM, and then we see the number dialed and the number forwarded to. Yes, sir.
And then the next one is 5:25, and again, the same date, January 9, 2015, a minute later. So it says 3:12. We understand the conversion. And that again has no connection with Jeffrey Williams. Fair to say?
That's fair.
Then the next one, next several ones, is again, Mr. Winfrey, same date, a minute later, calling Jeffrey Williams' phone, no connections. Fair to say?
Yes.
All right, and if we go to the next round. And that's going to be 2:21:15, and it's Mr. Winfrey calling Jeffrey's phone. You see that?
I do.
And that has a 34-second connection, doesn't it?
Yes.
All right. And that could be a call, could be a voicemail, but it could be a call. We believe it's a call.
We don't see VM notated under the features, so
We believe it's a call then. Fair to say?
fair to say.
Okay. And then the next one is same time. And it seems to be exact, it's the same date, same time, same amount of time elapsed. So for whatever reason, that's how the records read. Fair to say?
Correct. Correct.
Can you explain that? Because if you can, please do.
Yeah, I don't want to make assumptions, and I'd have to like start digging in. There's two entries there, two different seizure times, two different call times. So it's possible that the second phone call was at the same minute time. It's just two different phone calls, maybe elapsed over into the next minute. There could be an explanation in there, but we'd have to dig and read the key and get super in depth into it.
But the bottom line would be, to be fair, it may be a 34-second call.
Correct.
Okay. The next one. It's Mr. Winfrey again calling Mr. Williams, and that's the same date of February 21, 2015. You see that?
I do.
And that's no duration. Fair to say?
Correct.
And the next one is a little lower. The next day is February 22, 2015. And again, Mr. Winfrey's calling Jeffrey Williams, no connection.
That's correct.
And then the next one is about the same time, Mr. Winfrey's phone calling Jeffrey Williams' phone, no connection. Fair to say?
Yes, that's fair.
And then the next one is about the same time. It looks identical, actually. And it's a 7-second connection, but that's what you explained to the jurors, could be a voicemail.
It appears the records indicate that there's a voicemail.
Okay. And then Mr. Winfrey, I don't know, what is that, 21 minutes later, same date though, February 22, 2015. You see that, calls again, Mr. Williams, Jeffrey Williams' phone, but no connection. Fair to say?
Correct.
And then the next one, and I'm on 2093. On February 22, 2015, again, no connection. Jeffrey Williams' phone was called by Mr. Jimmy Winfrey, correct?
Correct.
And then the next one is going to be the same time, same date, February 22, 2015. And again, that's the voicemail that you explained to us.
Correct.
All right. And then the next one is going to be the same date, but later. And you have Mr. Winfrey again calling Jeffrey Williams' phone, no connection.
Correct.
Then the next one is the exact same date, and there's a 1-second connection. And Mr. Winfrey again calling Jeffrey Williams, right?
Correct.
And then the next one is the same date, maybe an hour and a minute later, Mr. Winfrey again calling Jeffrey Williams, no connection, right?
Correct.
Now we're on 2 days later. It's February 24th, 2015. Mr. Winfrey is connected to Jeffrey Williams' phone for 1 minute and 6 seconds.
Correct.
Okay. Is that the first time that the two phones connected so far?
Through these records for phone calls, yes, sir.
Okay. All right. Then the next one that we see is the same exact day, which is February 24th, 2015. You see it?
Yes.
And then same exact time, the 23:23. See that?
I do.
And then for whatever reason, one of them says a minute 6, one of them says a minute 5. You see all that?
Yes,
Okay. It seems like same date, same time, and a second off for the connection.
correct. Different dial length of times, but second off the connection time, yes.
Yeah. Can you explain that without, with all your,
I mean, we'd probably have to dig into more, but it would be an assumption on my part without digging into the records, AT&T, and studying how they do it more. But it could be just when the call's connected versus it hangs up and then calls again. It could be something internal with AT&T, why it's duplicating in such a manner, but there's a different dial length of time and there's a different connection time is what we're seeing there.
okay.
Yeah.
The next one is a day later. It's again, Mr. Winfrey calling Jeffrey's phone, right? No connection.
Yes, sir.
And then right under it, same scenario, same date, same time, but it's no connection, basically. And Mr. Winfrey's calling Jeffrey Williams. Fair to say?
Correct.
So far, has Jeffrey Williams called Mr. Winfrey ever
Objection, Your Honor, ever.
on these
I'll
records?
sustain the objection as to form.
Excuse me, I'm obviously talking about the records.
Agreed. On these records, what we're looking at, we have not yet seen the other number calling the 3383, the 8553 calling 3383.
And just because I'm a named person, the number that you've associated through your investigation, Jeffrey Williams, so far, I'm not saying it doesn't change, by the way, so far has not called Jimmy Winfrey's number that we associate with Jimmy Winfrey.
Correct.
All right, let's go to the next one, if that's okay. Are we at the next one? Okay, I'm sorry, I lost my way. Okay, now it jumps to, let's see. See the April 29th, 2015?
Correct.
Now, I want to take a second on this, if you don't mind. The other Jimmy Winfrey cell phone showed it was April 28th, 2015 contact. Do you remember that?
Yes.
Can you just explain to the jurors how these records align, even though one says April 28th, 2015, one says April 29th, 2015?
It's just that UTC thing again.
Just explain it to me if you don't mind.
This is showing the 29th because it's basically 12:10 p.m. UTC is what, or AM, excuse me, 12:10 a.m. for that GMT UTC time. And the other records will likely show 4:28:15 because it's already converted. Sprint's already done the conversion to Eastern Standard Time. So although it looks like different dates, it's actually, they're actually talking about the same time.
Okay, and thank you so much. And then the next one, that doesn't connect again, right? That's Mr. Winfrey calling Jeffrey Williams, right?
Correct.
Or the phone's associated with them. And then the one underneath it, it's the exact same time and duration, but they have it as 2 different contacts. You see that?
Correct.
All right. Next one. Then goes to the top. That's,
We jumped from like 28 to 78. I think.
can we do that again? Thank you. Can you go back to 28?
You see what I'm saying, Mr. Steele?
I see what you're saying. You have the physical records in front of you?
No, not for the whole spreadsheet. It's on a disk. They didn't give me the whole spreadsheet for that.
See if she could do it this way. I'm sorry. 23 is, it says 4/29, 2015. Can you get to 24? Okay, thank you. All right, and thank you so much. All right, the next one is May 6, 2015. You see that?
I do.
And just for completeness, item number 6163, right?
Correct.
All right, and that again, Mr. Jimmy Winfrey calling Jeffrey Williams' phone
Yes,
and no connection, fair to say?
correct.
The next one is the same date, May 6, 2015. A minute later, it's the same thing, Mr. Jimmy Winfrey calling Mr. Jeffrey, what we're designating this for the purposes of this communication, Mr. Jeffrey Williams' phone, correct?
Correct.
And no connection, right? Is that true?
Yes, I'm sorry.
Right. Now we have on May 6, 2015, this should be the first time, if I'm wrong, correct me, but this is Jeffrey Williams' phone calling and connecting to Jimmy Winfrey's phone for approximately 5 minutes or 4 minutes, 52 seconds. Does that sound right?
That appears correct, yes.
All right. And is that the first time that you remember, the jurors will remember too, that Jeffrey Williams' phone called Jimmy Winfrey's phone?
I mean, from what we've done today, yes.
Okay. And that would be May 6, 2015, right?
Correct.
All right, great. Okay. The next one should be right under it. You see that, May 6, 2015?
Yes, sir.
And that is pretty much after that call ended, that 4 minute, 52 second call. Now we're at 20:06. Is that fair to say?
Yes, sir.
And that's Jimmy Winfrey calling Jeffrey Williams' phone, a minute and 16 second connection, presumably a contact.
Correct.
All right. And then the next one is again the same date. It has the same time and it has the same duration at 1 minute, 16 seconds. You see that?
Correct.
All right. So I can't explain. I know you said you could assume, but you have to dig in.
Yeah,
Same-
we're trying to.
Same answer?
Mhm.
Okay.
Correct.
The next one is again, May 6, 2015, 7 minutes later. And that is again, Jimmy Winfrey's phone calling Jeffrey Williams' phone, connection of 56 seconds.
Correct.
The next one is the same date, the same time with the same duration, 56 seconds. We're gonna have the same answer.
Correct.
You'd have to dig in, okay. May 6, 2015, again, Mr. Jimmy Winfrey is calling Jeffrey Williams, and that's a minute and 3 second connection phone conversation that we're assuming phone
Correct.
conversation. Okay, the next one is May 6, 2015. Again, and you have the same exact duplicate that we've been talking about.
Correct.
Okay, so whatever it is. Then the next one is May 6, 2015, 2 minutes later, and Jimmy Winfrey is calling Jeffrey Williams' phone, no connection.
Correct.
And then the next one we have is item number 6173. Again, May 6, 2015, and it's Jimmy Winfrey's phone calling Jeffrey Williams' phone, no connection. Fair to say?
Correct.
And then it's same thing, same time, and it goes to voicemail as you explained to the jurors.
Correct.
And it's Mr. Winfrey calling Jeffrey Williams' phone and forwarded the whole thing you explained before.
Correct.
All right, let's go to the next one. May 6th again. Again, Jimmy Winfrey phone calling Jeffrey Williams' phone, no connection. Is that fair to say?
Correct.
Again, May 6th, 2015, Jimmy Winfrey's phone calling Jeffrey Williams' phone, no connection.
Correct.
The next one is number 6177, May 6th, 2015. Again, Mr. Winfrey calling Jeffrey Williams' phone, no connection. Fair?
Fair.
And the same is going to be for the next number, and then the next one is going to be that voicemail as you explained to us, so that Jimmy Winfrey's calling Jeffrey Williams' phone, and presumably, I'm not saying he is, but leaving a voicemail. Or
Correct.
more voice message.
I understand. Yes, sir.
Okay. And then the next one, if you don't mind. It's May 8th now. It's a new date, 2015. It's line number 6346. And again, Jimmy Winfrey's calling Jeffrey Williams' phone, no connection. Fair?
Yes, sir.
And then it's the same quadrant we're in because they're similar, but Mr. Winfrey's calling on the next number, 6347. Mr. Jeffrey Williams' phone, no connection. And then Mr. Winfrey leaves a voicemail according to these records.
Correct.
All right. And the next one. Now we're at May 15th, 2015. And this is Jimmy Winfrey calling Jeffrey Williams' phone, no answer, or no connection. Fair to say?
Correct.
And the same thing for underneath it.
That's correct.
And then it's just kind of a pattern. The next one, Jimmy Winfrey leaves a voicemail of 6 seconds. Fair to say?
Correct.
All right. Now we're up to today's date, but 9 years ago. And again, Jimmy Winfrey's calling Jeffrey Williams' phone, and there is a conversation for 3 minutes or 2 minutes, 59 seconds. You see that?
I do.
And then underneath it, it's the same phenomena that you said you'd have to dig into, but it's the same date and time and the same elapsed time, 2 minutes, 59 seconds. Mr. Winfrey calling Jeffrey Williams' phone. You see that?
Correct.
All right. And then underneath it, 3 minutes later, you have Jimmy Winfrey's phone calling Jeffrey Williams' phone for 3 seconds, no connection. True?
That's correct.
And then that's going to be the same for the next item, a 6-second dial, but no connection. Jimmy Winfrey's phone calling Jeffrey Williams' phone, right?
Correct.
And then on item number 6938, we have a 5-second connection, but you explained that that's a voicemail that is left, presumably left by Jimmy Winfrey or the holder of that phone, the 3383 on Jeffrey Williams' phone, 8553. Fair?
Correct.
All right, if we go to the next one. Now we're up to May 21 of 2015. Again, you have Jimmy Winfrey calling Jeffrey Williams' phone, and that's a 16-second connection. Fair?
Yes, sir.
All right, and the next one. We have May 21 again. You have Jimmy Winfrey's phone calling Jeffrey Williams' phone for a 15-second connection. Right?
Correct.
And then the next line, Jimmy Winfrey's calling Jeffrey Williams' phone, May 21, 2015, no connection.
That's correct.
And that goes on for the next 2 calls. And then again, we have the voicemail from Jimmy Winfrey to Jeffrey Williams.
Correct.
All right. The next one. Is May 21, 2015. You see where it says Jimmy Winfrey's phone does not connect with Jeffrey Williams' phone?
Correct.
And then the same thing for the next call, fair to say. And then you have that voicemail phenomenon, 8 seconds, correct?
Correct.
And the next one is on the same date, but later, and you have no connection between the 2 phones, fair to say?
Correct.
And then you have on May 21, 2015, line 7390, you have a 7-second connection for the phenomenon of the voicemail that you explained.
Yes.
I don't know if it's a phenomenon, but
Phenomenon.
the
yeah.
code, the code.
The
voice.
code, yeah.
All right, and then the next one, we have Jeffrey Williams' phone on May 21, 2015, calling for 17 seconds, Jimmy Winfrey's phone. You see that?
I do.
All right. And that relationship between the calls of Jimmy Winfrey to Jeffrey Williams is about a minute later.
Correct.
All right. And is that the second time that Jeffrey Williams' phone called Mr. Winfrey's phone?
What we've seen today, yes, sir.
All right. Okay, the next one would be May 21, 2015. Again, no connection, but Mr. Winfrey's phone's calling Jeffrey Williams' phone.
Correct.
And the next one is right underneath it, same exact response. And it looks similar. I'm not saying it's the same, but it looks similar.
Yes, sir.
No connection. Okay. Now we're up to May 21, 2015. You again have Jimmy Winfrey's phone leaving the voicemail for Jeffrey Williams' phone, 4 seconds. Fair to say?
Yes, sir.
Then the next one would be May 22, 2015. That's Jimmy Winfrey's phone calling Jeffrey Williams' phone. There is a 1-second connection. It says no elapsed time, whatever that is. That's what the records read, right?
Correct.
But underneath it, it has a voicemail component to it. Jimmy Winfrey's phone calling Jeffrey Williams' phone.
Correct.
Same time, same date. Okay. The next one. Now we're at May 24th, 2015. You have Jimmy Winfrey's phone calling Jeffrey Williams' phone, and looks like a conversation, a potential conversation, 37 seconds. Fair?
Yes.
And then right underneath it, it's the same exact information, except one says 10 seconds and the other one says 14. Otherwise, they both have 30 seconds.
That's correct, sir.
37 seconds. Okay. Next. Now we're up to June 1st. Now you have Jeffrey Williams' phone calling Mr. Winfrey's phone, and it's a connection for 2 seconds. You see that?
I do.
And then right away, you have Mr. Williams' phone being called by Mr. Winfrey's phone, and there's a conversation that appears to be 1:40. Fair to say?
Yes, sir.
And then the records seemingly, I'm not saying there's not a reason for it, but they seemingly duplicate that same contact.
Correct, sir.
All right. And now we're in,
Text messages.
yes, sir. So this would be a text message from Jimmy Winfrey's phone to Jeffrey Williams' phone
That's right
on
here, sir.
April 5,
Yes, sir.
2015. And it looks like consecutive item number 1073 and 1074. Fair?
Yes.
All right. And that just picked up, that item number just picked up the phone
Correct.
number. Okay. And then you have, we went backwards. We have at the bottom of the screen. That's the end? Okay, that's back to beginning. So from all of that information, there are two, I call them text messages, but I think you said SMS messages.
Correct.
And that's on April 5, 2015, correct?
Correct.
And they're at 14:28, so you subtract the 4 hours, so we're talking about what time? 10:28 in the morning?
Something like that. Yes, sir.
Okay. And they were both from, if you didn't notice, they're both from Mr. Winfrey to Jeffrey Williams. Fair to say?
I believe that. That is what I recall. Yes, sir.
Okay. So out of the 70 plus hits, we have Jeffrey Williams calling Mr. Winfrey a total of 4 times, 3 times.
I believe that's accurate. Yes, sir.
On May 6, 2015 for 4 minutes, 54 seconds. Remember that?
Yes, sir.
On May 21, 2015 for 17 seconds. And on June 1, 2015 for 2 seconds.
Yes, sir.
And no text messages from Jeffrey Williams to Mr. Winfrey, according to these records.
On this phone for this service, that's correct, sir.
I just want to put in perspective.
Outstanding objection.
But you do have Mr. Jimmy Winfrey calling, whatever, I know he has 4,000 calls in a month, but calling Jeffrey Williams, the number of times that we saw, over 70, right?
Correct, sir.
Most of them went unanswered and not replied to, according to these records.
On this record for the service, that's correct, sir.
All right. And you're saying that because you want to be accurate, because you don't know if there's multiple phones, other types of connections. That's what you're just saying on these records, that's what that shows.
Correct. I'm qualifying it because that's these records. There's apps, there's FaceTime, there's other methods of communication that aren't captured on these records with this data. So that's why I'm qualifying it.
And you want to be fair to the jurors to know, but this is the evidence we have.
Correct. This is AT&T records for standard phone calls and standard text messages, but there's other applications, other services that can be utilized to communicate that aren't captured on these records.
Right, but we
And
can't,
other phones.
and we can't, like you said, we can't speculate, so this is what we have.
These are the records that were collected from AT&T. Yes, sir.
Okay. Now, I'd like to talk with you about the sister of Jeffrey Williams.
Okay.
Do you know, and I heard you say you can't differentiate the people, that doesn't matter for the purpose of this, but do you know the sister with the 1990 number? Do you know who you would refer that person as?
No, I just know the two Greer sisters, and I know the name, Amina Diop, that the records were in. But no, I did not do a deep dive into the sisters or anything like that.
Okay. the 1990 number. That is, you got phone records for that number, didn't you?
We did.
Okay. And that's been admitted, I believe, check me if you can. One state's exhibit number 134E. Just tell me if I'm wrong though, please.
134E. That appears correct.
Okay. Donna, can we show 134E state's exhibit? It's already been admitted into evidence.
Yes, you can.
Thank you, sir. Okay, and I think that Haley just put it on the screen. You see where it says, and she highlighted it for us. I just unhighlighted, but you see where it says the phone number there?
I do, sir.
All right. And this number was also used a lot with the graphic. You got historic cell site location data for that phone, didn't you?
Historical cell site data, yes, sir.
And that's how you were able to show the towers and the towers that were employed by that phone when it connected to, and you did it, you gave us different areas on the circular map.
That's
Remember
correct. Yes, that's correct, sir.
All right. Now, were you aware that, or do you associate this phone with a woman known as Dolly, by any chance, Jeffrey's sister Dolly? And if you don't, that's fine.
I've heard the name come up, but again, my part of the investigation in reference to this incident, I didn't dig deep into, the sisters or the names, sir.
Okay, that's fine. Well, can we just call it one of Jeffrey Williams' sister's phones?
That's fine by me,
Or the
sir.
sister's phone just for ease, is that okay?
This is the YSL Enterprise phone. Yes, sir.
And through your investigation, you believed that it was used by Jeffrey Williams' sister. Fair to say?
That's fair to say.
All right. Now, this phone is clearly in Atlanta because you were able to get the cell site historical data.
That's correct, sir.
All right. And this phone also was called in a jail call. If you remember that you explained to the ladies and gentlemen of the jury, there was a discussion and what is the number, and that number actually, the 1990 number, is actually on and captured on a jail call that the ladies and gentlemen of the jury heard. Fair to say?
That's correct.
And during that jail recorded call, Jeffrey Williams actually gets on that call. Do you remember that?
I do.
And he was at an event, they talk about in that call, an event for the Free Roscoe campaign. Do you remember that?
I do remember Free Roscoe being mentioned, yes, sir.
And there were various people on the call, but they were saying that the event is whatever, tuned up or whatever, but popular. It was going on right then and there. Correct? It was
Yes,
at a
sir.
park.
Yes, sir.
All right. Now, did you know Dolly, excuse me, the sister, had a relationship with Jimmy Winfrey in 2015? Were you aware of that?
Objection, Your Honor,
I sustain the objection.
Through your investigation, did you gather evidence that Jimmy Winfrey and the sister were in a relationship?
No, sir.
Do you remember on a jail call, if you remember, between Jimmy Winfrey and the sister talking about you cheated on me and we were going to get married? Remember that?
I don't remember that, sir.
Okay. During a break or in front of jury, but I may want, you heard jail calls on this case, right?
I did listen to jail calls, yes, sir.
I may refresh your memory and then, or try to refresh your memory.
I sustain the objection, Mr. Silcom.
I will come, okay, we'll come back to that. Do you know, as you sit here now, the relationship between the sister and Jimmy Winfrey in and around April 2015?
No, sir. My investigation was focused on basically the shooting and what happened and who did it at that time. I didn't investigate the sister or anything like that, no.
Okay. Obviously, the sister is not, I shouldn't say obviously. In your investigation, was the sister phone in the same location as the Jimmy Winfrey phone on the early morning hours that you helped us with on April 26, 2015? Were they in the same like vehicle, let's say?
Objection to speculation about being in the same vehicle.
I sustain the objection.
According to your investigation and the plots that you showed us, were those two phones together?
Objection to speculation as to whether or not the two phones were
I
together.
sustain the objection.
Based upon your work in this case, did the two phones diverge? Meaning one is hitting off a cell phone that the other one is not?
That's correct. They're at the same time at basically different towers, I would say.
Do you have any evidence that the sister was in the white Camaro on or around the 25th day of April, 2015, going into the 26th day of April, 2015?
I don't have any evidence that the sister was in the Camaro.
And there were a lot of contacts, and we'll go over them, that the state put on the board, and you helped us create that board, between the 1990 phone and the 3383 phone, so the sister phone and the Jimmy Winfrey phone, during April 25th going into April 26th, and around that time. Is that fair to say?
Correct.
Do you know what was the discussion between those two phones or the parties on those phones?
I have no way to know the content of those phone calls.
Okay. All right. Now, I'd like to go through using this, the 1990 AT&T records. And for AT&T records, we do have to do that conversion. I'm not going to ask you to do it, but the jurors will remember. Fair to say?
Fair.
And this is the sister, well, I'm calling what you investigated, the sister's phone, and it's. Is that fair to say?
Yes.
All right. So if we can put in the contacts between the sister's phone and Jimmy Winfrey's 3383. And see how many contacts we have. Now, to be fair, tell the jurors, because I should have oriented them, what are the dates of these records that you got for the 1990 phone?
Oh, we see January 1st, so I spanned it to there. Let me see if, probably easier if the,
See it on the screen?
yeah, the person operating it might be able to do it faster because we only did the snippet of the records here. So it's ending on May 27th, 2015.
So this one's going January 1, 2015, just about 6 months, right before June 1, 2015, but specifically May 27, 2015.
That's what we see here on the screen. Yes, sir.
All right, so if we could go back. And between those dates, of approximately 6 months, I know it's not perfect, but according to these records, and you've already explained some of the records seem duplicate, but according to these records, it's going to be 367 contacts between the two of them in the approximately 6 months. Fair to say?
That's what these records show.
All right. Hold on 1 second. Now, we had the total hits of 367. If we go to April, if you need to see anything else, just let us know to explain it to the jury to make it complete. But we go to April 2015, okay?
Sure.
And look at the first hit. When I say hit, I'm talking about the connection.
So we got there.
You see it?
For April?
Yeah. Okay. So we start with the first day of April, and you have Mr. Winfrey calling, and I'm not going to go through all these, but the general scenario, you have Mr. Winfrey calling, and you'll see Miss, we're going to go through them, you see Miss, or the sister's phone trying to call Mr. Winfrey phone, if we're just going to go through them, okay?
Okay.
And if you see anything that's of interest, just stop me, but I'm just going to scroll. There's no contact so far. And it went from April 1 to April 5, fair to say?
Yes, in these records, that's correct.
And then we're going to go again. Well, we skipped, so let's go back. So you have April 5, and there's communication between both phones, and they're calling each other. Did you notice that? The phones are, the 1990s calling the 3383, and the other way, 3383 is calling the 1990. Fair to say?
Correct.
Okay. And sometimes they connect, sometimes they don't connect. Sometimes it's for 4 minutes, sometimes it's for 3 minutes, sometimes it's 0. Fair to say?
I think that's fair to say.
Okay. And then we're in 4-5 at item number 11560, 11,560. You could continue. Now we're at 4-6. 4-7. Now we're at 4-8. 4-9, the next day. So far, these phones, I'm not saying it's every single day, but they connect a fair amount. Is that fair to say?
For someone in a relationship, I don't want to judge that, but they connect.
Okay.
They connect throughout the month, but
Okay.
I don't know if it's a lot or not a lot. I don't.
Fair enough. And if people are together, they don't have to use their phones potentially.
That's also true.
And then next one is 412. And it's just, and then we're going to stop and look at some of these documents, but they're speaking, and then you explained to us the 426 connections, didn't you? And if not, we can go through them.
You told me on direct?
Yes.
Yes, we talked about the 426 connections.
All right. Then I'd like to go to
Mr. Steele, before you transition, I have good authority. We need to take a comfort break. So why don't we do that for 10 minutes? So ladies and gentlemen, we're going to take a comfort break for 10 minutes and then we'll see where we go from there. Okay. All right. We're in recess. All rise. All right, ladies and gentlemen, our jury has left us, so we'll be in recess for 10 minutes. Thank you. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Ladies and gentlemen, I have it on good authority that some of you are hungry and want to eat. So we're going to go ahead and yield to that request and break for lunch at this point in time. So if I can have you all come back for, it's 12:45 at this point in time, 1:45, and we'll get started shortly thereafter, okay? All right. All right, so we'll be in recess until 1:45. All rise. All right, ladies and gentlemen, our jury has left us. We're in recess until 1:45, okay? All right, thank you. summon our jurors, please, sir. All right, ladies and gentlemen, please be seated.
All jurors present, count four.
Thank you, Sergeant. All right. Mr. Matthews, Senior, good afternoon, sir. All right. Okay, Mr. Steele, you may resume your examination, sir.
Thank you, Your Honor. So I'd like to show you what I'll mark as Mr. Williams' exhibit number 224. Yes. Highlighted US for ease. To refresh his memory. Do you remember I was asking you questions about whether you knew that the 1990 number, Jeffrey's sister's number, belonged to a woman named Dolly? Do you remember that?
Yes,
Okay, and you said, I believe, I wasn't sure, I just call her a sister, something like that?
something like that. Yeah, Dolly sounded familiar, but yeah, she wasn't the target of my investigation. So.
Sure, I'm not suggesting she was. And then, do you remember me asking you about whether you had information that Dolly and Mr. Winfrey, Jimmy Winfrey, were in a relationship? Remember that?
Yes.
Okay. And do you remember that as you sit here now, or?
If they're in a relationship or not,
Yeah.
I don't know. It wasn't, again, it's not the focus of my investigation.
Let me show you what, with the court's permission, what I've marked as Mr. Williams' number 224, and it's slide 5, I believe, from your PowerPoint. Do you know what I'm talking about?
The PowerPoint?
Yes. You do a PowerPoint?
Show it to the.
Yeah.
Show it to the state, please, first. Did you already show it to the state?
Yeah.
Okay. Ladies, have you seen it?
Yes.
Okay, all right, good. Yes, sir, you may approach.
May I approach?
Yes.
Yes, sir.
And just mark Mr. Williams' number 224 for purposes of seeing if you recognize it and refreshes your memory.
Did I write this, sir?
listen, if you don't recognize it, I know it's been a long time, don't worry about it. If it does not refresh your memory, just say it does not help my memory.
Yeah, I don't recognize this as being my work product.
Okay, then we'll just put it aside for the court reporter and just ignore that, okay?
Okay.
Thank you for looking at it. 224.
224, Jeffrey Williams, 224 for identification.
Okay,
No, it's been identified for the record.
all right. I want to go to the 1990, the Dolly or the sister, whatever you feel comfortable with.
Yes, sir.
Records, and we were in April, I believe. Is that your memory?
That's accurate, yes, sir.
When we broke, okay. Now, you talked about, we're up to April 18th, and the real relevant dates that you focused on is April 25 and April 26. Fair to say?
That's fair to say. That was the main focus of the investigation. Yes, sir.
All right. So let's just go through this again, just showing the context, but I'm going to then stop at the April 25, April 26, okay? These are the contacts between the one that's on the board showing in state's exhibit number 134E is at it's number 1414091, and it's April 18, 2015, and it's the Dolly number or the sister number calling Jimmy Winfrey number, 3-second connection. You see that?
I do.
And that's, next one is 418, and this is the same thing, no connection, but it's again, the Dolly sister number calling the Jimmy Winfrey number. Fair to say?
Yes.
All right, the next one, again, the same date, 418, but this is the Jimmy Winfrey number calling and connecting for 46 seconds, as far as we know, according to the records, with the sister's number, right?
That's correct.
All right, we're getting close here. Next one is 419. And again, it's the sister's number connecting or calling and connecting 1 minute, 59 seconds with the number to Jimmy Winfrey.
Yes.
Correct?
Yes.
All right, now again, 419, it's the same scenario. Sister calling Jimmy Winfrey, 14 seconds, right?
Yes.
Next one is 420. And we are at a 34-second call. And again, it's the sister calling Jimmy Winfrey.
Yes.
The next one is a 3-second call, the same date, 420. Sister calling Jimmy Winfrey.
Yes.
The one after that is again, later that same day, 2-second connection. Same situation, fair to say?
Yes.
All right, then we go to 423, and you have the sister's number calling Jimmy Winfrey. That's a 7-minute, 5-second communication as far as we can tell from the records, fair?
Fair.
All right, and then the next one again is later at 423. It's a 2-minute, 14-second contact, and that has Mr. Winfrey calling the sister.
Yes.
All right. The next one is the 15,003, 424:15, and that's a 1-minute connection, and it is the sister calling Mr. Winfrey.
Yes.
Now we're at 426, and we have to do the conversion for these records, fair to say?
Yes.
So even though it says 426 at 3:06, you move back 4 hours, so we're really right before midnight.
11:06.
Okay, at night, 11:06 at night.
Correct.
All right.
11:06 Eastern.
And we're really on Saturday, the 25th of April, fair to say?
Correct.
And that is the sister 2-second connection calling Jimmy Winfrey, right?
Correct.
Okay. And then they talk or try to connect, whatever the right word is, but the phones on the record show some sort of attempt later that day, and that's right after midnight. And you went through these calls with the state, fair to say, on direct examination, so the jury see it?
We did.
All right. I'd like to use these records, if I could, for the call between the 1990 number, the sister's number, and the Martinez Arnold. Remember talking about that with District Attorney on direct for the jury?
Yes,
And Martinez Arnold, correct me if I'm wrong, but I'm going to tell you it's 5790. If that's wrong, just let me know.
that sounds correct.
Okay, and if you need to check it, I'm sure it's in front of you, just please make sure. All right, so if we look in April, you focused on, and this is exhibit number 134E. And this is April 26th. And do you see that 5790 YSL Duke?
Yes,
All right. And that's at 7:07. And that's important because if we subtract the 3 hours, excuse me, all right, subtract the 4 hours, we're at 3:07 a.m.
that's correct.
on the day of the shooting. And we know from your testimony and from the jurors heard the 911 call, that's a 3:14 911 call. Fair to say?
That is correct.
All right. Now analyzing this, and it's lit up by Haley as item number 15,240. You see that?
I do.
And this is a call, presumably from the 1990 Sisters number to the YSL Duke phone. Fair?
Fair.
And I know I'm not going to ever repeat it. We don't know where the YSL Duke phone is or who has it. Fair to say?
Fair to say.
All right. And that is a 3-second total connection.
Correct.
All right. Then immediately underneath that is the 15,241. So it's the next entry. You see that?
I do.
And this is what you discussed with the prosecution as well. It's the exact same time, right?
Yes,
3:07.
3:07, correct.
And it's the exact same duration of the initiation of the call, the 2 seconds, fair to say?
That's correct.
And then it has an extra second of the elapsed time.
That's correct.
So it has 4 seconds.
Correct.
But this one has an F. Can you look at your cheat sheet for this is AT&T records, correct?
Correct.
Can you just figure that out for us if you don't mind?
So the CFNR, which we see to the right, is the furthest right thing highlighted. That stands for call forwarding no reply. So it attempted to call forward and no reply is what,
Explain it to the jury, just so people may understand that, but some people may not.
well, attempted to call forward and I guess it would be an assumption of AT&T without asking AT&T what that specifically means. But it's call forwarded and there's no reply. So I guess the voicemail did not answer. The voicemail did not pick up. I'm not sure what that means.
Okay. And we don't see the YSL Duke phone number ending in 5790, should be. We don't see that connecting to the Dolly number, the 1990, or the sister number, 1990. Fair to say?
And what we're looking at, that's fair to say, correct.
Okay. All right. I'd like to ask you, on these records, just going down now, and if it's important to say who the person is calling, you know, the numbers, just say that. But I just want to continue, if you don't mind. It goes from, you see it's 7:07, which I know is 4:07 in the morning. So we're talking about 7 minutes before the 911 call, fair to say?
Yes.
All right. And then the next one is 7:08. You see that? It just went away, but
We're still talking about the 5790. You said anything important, but you're specifically talking about 5790.
5790, just the use of the phone is what I'm saying.
Okay.
So it was used at 3:07. I'm doing the conversion.
I'm tracking. I'm just trying to make sure I understood your question about importance because
The next one is to Jimmy Winfrey's number is 7:08, correct? Or let me,
the 708 time. Yes, I see what you're saying. Yes.
which would be now 6:08, which is 8 minutes before, no, 6 minutes before the 911 call.
Correct.
All right, and if we go down to the next one. Okay, and it's item number 15,246. See that now it's 714, which will be
314.
314, which is identical to the time that we believe the 911 call. Fair to say?
Fair.
And that is again calling the Jimmy Winfrey phone from the sister phone, right?
Yes.
And then 715, you have the same Jimmy Winfrey phone calling the sister phone. And when I say 715, we're subtracting 3 hours. So it's a minute after the 911 call.
Yes.
Okay. And then there's the usage at 716 or 316 and 318, then 10 minutes later, 328, 336, and the jurors can see it. But up until 738, the phone was being used, except for that 10-minute break, pretty much every minute. Fair to say? According to the records.
Say that question one more time. That from what time to what time was being used every minute?
You see the 10-minute break from 728 to 736?
Yes, yes. I see what you're talking about. Yes.
And then you have 737, 737, 738, 738. That's what I was just saying.
Yes.
And then there's another break for approximately an hour and a half.
Well, it was 738 to the 753.
Oh,
and
I
then
missed it. Thank you. I apologize. Explain that to the jury.
no, after the 738, which is 338, there's the jump to, what is that, like, with 15, 20 minutes, whatever it is
15
after.
minutes, yeah.
Yeah. And then we get to 753, where the 5790 connects. So that's 353. Well, again, connects is, they try to communicate, but it looks like it didn't go through and it hit the call forwarding again.
Okay. All right. With regards to Jimmy Winfrey's phone. So this phone, the 1990, the sister's phone, according to the records, the phone is being used or trying to be used, meaning trying to connect during the relevant period of time that we believe the shooting is occurring or has occurred. Is that fair to say?
Correct, around the approximate time, yes.
Do you have any evidence that you've done through your investigation that any app or FaceTime or anything that doesn't show on records was being used by that 1990 phone during this time?
I have no way of showing that.
Okay. If we go to well, before we leave the the sister's records, can you just do me a favor? I'm going to go back to the Shannon Stillwell, or Shannon Jackson rather, number. I think that's the number that you said ends in 3059.
Correct, that's just the number we had in the police report. I didn't do any legal process on that phone number.
So, and by that, just to jurors understand, there's a good faith belief you wouldn't put in your report. I'm not saying you'd make up that that's a number associated with Shannon Jackson or Shannon Stillwell, but you didn't verify that beyond that. Is that what you're saying?
So that phone number may or may not be his phone number at the time of the incident. The way that our records management system works is when we're putting in the names or they're getting entered from patrol or an investigator, it goes through a name candidating process. So you don't have duplicate entries for the same David Racy. And so if the name has already been entered and it's being entered in again, it'll pull the information from that prior entry. So that phone number, just because it's in the police report, that's just a phone number that's associated with him somewhere in Cobb County records, somewhere, somehow, sometime. But the accuracy of that, I have no way of knowing. If I didn't do a legal process on it or didn't do an independent investigation trying to query it, then that could be inaccurate for Shannon Stillwell's phone number, or it could be accurate because it came in there somehow, some way, whether an accident report, a ticket, whether it could come in there multiple different ways into the record management system.
With that background, with your permission, I just want to search that number.
You can search that number. Yeah, absolutely.
Okay. Haley, do you mind searching that number? Thanks. And just make sure she's putting the correct number, if you don't mind. That look right?
Page 13. I'll just check it just for accuracy.
Page 13, according to me. Yes, sir.
Yes, that appears accurate.
And then just tell the jurors in this honorable court what the result is on the Dolly record. Well, excuse me, I keep missing one. The sister record 1990.
No matches were found.
All right. I'd like to do, now go to Jimmy Winfrey records, if you don't mind. And Your Honor, that is in evidence, and that is 133E, with the court's permission.
Yes, sir.
Thank you. And this should be the 3383 number, fair to say?
2383.
And just for orientation, this is the 30 days, April 1 to April 30th,
Correct, sir.
2015. Okay. Now, if we can just do a quick search for Shannon Jackson or Shannon Stillwell's number with the caveats that you gave us.
Sure.
Haley, if that's okay. Do you need the number again? And this is showing on the honorable court screen before the honorable jury. This is Mr. Winfrey, state exhibit number 133A, the 3883, okay?
Yes, sir.
All right. Did you do this, sir? Is that because it's covered? Okay. We can scroll down. Did you hear what she said?
I heard what you said.
Do you have? No, that's okay. That's okay. She just scrolled down for that 1 month. Do you see any connection to the Shannon Jackson, Shannon Stillwell potential, I'm using that word, phone number here in these records?
And for clarity, which of the two numbers are we using and are we searching both numbers?
We'll do both.
Okay, thank you.
One sec. I understand, but just show the jury the whole month and that if there's something lit up or something not lit up. And then run the second number as well. Agent, do you know the second number? Can you announce that? I think there was one digit off.
9573059.
Have you noticed anything highlighted?
No, sir.
Okay. Okay, now staying with the Jimmy Winfrey records. And these are the Sprint records, correct?
Sprint, yes, sir.
Okay. Now, going at the time, what I'm going to call the relevant time, jurors obviously make that decision though, but from the late night on the 25th of April, going into the early morning hours of 26th of April, so Saturday night to Sunday.
Yes, sir.
If Haley can help us out with those dates. Okay. Okay, you see where Okay. Let's just orient well, when she stops. Let's orient everybody. You see, these don't, what you tell the jurors, do these need to be converted 4 hours earlier, or are these already in Eastern Standard Time?
No, as we stated before, the Sprint already converts it to Eastern Standard Time.
So starting towards the top, you see the item number 3796?
Yes,
Okay. And that is April 25, 2015 at approximately, that would be 10:28 in the evening?
correct.
All right. And then just seeing the flow there, that is, this is Mr. Winfrey's, this is Mr. Winfrey's records, correct?
These are Mr. Winfrey's records.
Okay. Well, we're calling Mr. Winfrey record 3383. Okay, and then Mr. Winfrey, if we come down, and I'm just skipping just for ease, to 426. And I'm getting close to the time of the shooting, if that's okay. You can stop there. If you notice, there was a lot of trying to connect either one way or the other. People calling that number, the 3383 number, or the 3383 number, using the phone to try to connect to someone else. Is that fair to say?
There's a lot of communication going on the phone. It's fair to say.
And then I skipped ahead, but looking at, let's say, starting at 2:45 that morning, which is number 3845. You see Haley just highlighted?
Yes.
Then we see that there are calls to that 3383 number and calls from that 3383 number starting, and I'm just looking at the times now in column, should be in column E, is that correct?
Yes.
All right, so we have 2:45 a.m., then 2:48 a.m., then 2:49 a.m., then 2:55, 2:57, 2:58, 2:59, then 3 o'clock in the morning, which is 14 minutes before the 911 call. Fair to say?
Yes.
And then 3:02, 3:03, 3:04, 3:07. You see where I am at item number 3867?
Yes.
Okay. And then again at 3:07 and 3:08, numerous times, and then skips 6 minutes, approximately 3:14, the time of the actual 911 call. You see that?
Yes, sir.
And then it goes again, 3:14. And then it continues, and the jurors can see, 3:15 and 3:26. You see all that?
I do.
Okay. Now, there's a call in there to the number that's 2920, what we called the Brian Williams performer known as Birdman.
That's correct.
And can you show that to the jurors? Do you see that anywhere on here?
Yeah, she has it highlighted.
Okay. And that is a call for, and you told the jurors, do you remember how long that call is approximately?
535 seconds.
Give me an estimate.
So whatever that comes out to be, 60 seconds per, I think it comes out to be like, what is it, 8 minutes or something like that?
Yeah, just under 10 minutes. 10 minutes would be 600, so this is 535.
Yeah, so like 8.5 minutes, whatever it comes out to.
Sure, okay. Now, that call that is on Soundable Court's screen for the jury on State's Exhibit 133E, that is originally made, according to these records, 3 minutes after the 911 call. And
That's correct.
and it's about an 8-9 minute call, whatever the 535 seconds is, right?
That's correct.
Do you have any evidence that the Jimmy Winfrey phone was using any app or FaceTime during this relevant period of time to share with the jury?
Again, we don't get that in these records. These are for call data and text data records. That's the information that's requested. If we request data, we don't know what type of data is being used. It could be YouTube, it could be an internet search, it could be an app. We would have no way of knowing what data. We'd have to have the physical device to say, what apps are on the phone, what information's on the phone.
But according to these records, that phone was using the phone in the typical way. And when I say typical way, just hit send. that records would pick up during the relevant period of time of 3:07 to 3:14. Fair to say?
Correct. Standard phone calls are like pretty much what we're looking at right here.
Okay. Do you have any evidence that Mr. Winfrey's phone, 3383, was using one of the apps, international apps, FaceTime, whatever the apps are? Do you have any evidence?
Again, I don't have that in these records. That's not the information that I have in these records.
So the answer is
No, I don't have any information regarding that.
all right. Do you have any evidence that Jeffrey Williams' phone was using any type of app, FaceTime, that would not come up on his records during this relevant period of time?
Again, I have no way of showing that, no.
Do you have any evidence that Jeffrey Williams was awake during the relevant period of time of the shooting?
I mean, I don't know if someone's awake or not. You can make assumptions off the phone records if you want, but I have no idea of knowing that.
Okay. I'd like to go to Jeffrey's phone records, which is the 8553 number. If I'm wrong, you got to correct me, but that's what I believe is true.
I believe that's correct.
And I'd just like to look in the April 2015 phone activity between the Jeffrey phone, the 8553, and the sister Dolly phone, the 1990, okay? For April. And if Haley can do that, that would be great. Okay, and she put in the 1990, and that's the phone we're using for the sister. Fair to say?
Yes, sir.
And for the jurors to know, this is what we're calling Jeffrey Williams' number, the 8553, and it's in evidence states exhibit number 137E. Your Honor, it's on your screen. Okay, the first one is April 6, 2015. Do you see that?
I do.
And that is the the sister phone calling Jeffrey's phone. It doesn't connect according to these records. Fair to say?
Yes.
And then on the next line, it's the same exact time, 2026. And when I say line, entry number 4,219.
Yes.
And that again is the 1990 or the sister phone calling without connection to Jeffrey's phone. Fair to say?
Yes.
And then the next line is the same date. And it's 4220. It's the next entry. And that one goes to the voicemail like you explained to jurors.
Yes.
And it's the sister phone calling the Jeffrey phone. Fair to say?
Yes.
And then the next one is, again, the sister phone. It's at entry 4221. Same time. It's a connection of 3 seconds. You see that?
I do.
All right. Let's see the next time that these phones connect. Now, we're skipping a week on these records, right, from 4/6, which is April 6, 2015. Now it's going to 4/13, which is a week later. Fair to say?
Yes.
And again, you have now the two phones, and this is Jeffrey's phone calling without connection, the 1990 phone, the sister phone. Fair to say?
Correct.
And then on the same date, same time, it looks like the same exact replica of 16-second call, no connection. Is that fair to say?
Correct.
All right. And then the next time that these phones connect, we're in the month of May. Is that fair? May 9th?
Yes.
Okay. Okay, so according to these records, Jeffrey's phone and the 1990 phone connect twice. But I'm not saying they speak, but they try to connect twice. The 6th of April and the 13th of April, right?
Correct. Utilizing the normal voice to talk.
Absolutely. Okay. Your Honor, may I approach and do you mind if I use Your Honor,
Yes, you may.
thank you, sir. Yeah, I'm just gonna walk in. I know you helped prepare this. Do you mind taking a peek at this? Sure. It's just I have to orient myself. You might need a mic.
Yeah.
Okay. Then just- I'm skipping this because this is not your testimony, okay? This is part of your testimony, fair to say? Yes. Okay. When you went through the Jimmy Winfrey call, the 1990, what you were calling then YSL, I called it the sister's phone. Yes. Fair to say? On this entire page, do you see any connection to the, and you may have to help me with the number, the Jeffrey Wood 5883 number? 8553, I thought it was. Thank you. Yeah. Apologize. Do you see anything dealing with the Jeffrey Williams phone? No, from these like location plots, no, that we did. Am I correct? That's correct. Same thing with number 8? Correct, we were correct. And then was this you too? That was, yes. It was. And this is the, we're gonna come down to, it's not numbered, but at the bottom of this page? Yes. Does this have an exhibit number?
It does not.
Okay. I'm using just for reference, Your Honor, the demonstrative chart. That's
Which
been
one?
Written on.
You can mention a number, I think it would be a 176. Thank you.
So you want 176 Echo?
Ms. Weaver's confirmed.
Okay, all right. You can refer to it as 176 Echo, Mr. Steele.
Thank you, Your Honor. And what this is showing, it says the 8553 number on this date, I believe, is in Baton Rouge. If I'm reading it wrong, you have to correct me. That's correct. That's what that's all that is. Is that true? Correct. That's from my memory, yes. And this is the way that you said you can go 2 different ways if you're driving. Baton Rouge, this is the lower way to go. Yep, the spot checking and approximately where he was driving, that's correct. And that's how you knew. Do you know who Jeffrey Williams was driving with on April 25, 2015, going into April 26, 2015, from the trip from Louisiana to Georgia? I have no idea who's in the vehicles with him or who's driving. I have no idea. Do you know whether the YSL Duke, I'm gonna need help on the number, is that phone is in the car with Jeffrey Williams? I have no way of knowing that. When I say Jeffrey Williams, the phone associated with Jeffrey Williams. Okay, I'm just going to the next page. Anything here to do with the 8553 number, Jeffrey Williams? No, this was just for recollection. This is where we were spot checking location, so it wasn't an all comprehensive search of phone numbers, but this was just the spot checking that I did in my notes. Nothing to do with Jeffrey because his phone's not even in Atlanta, right? Correct. This was for the location of the 1990 phone is what we were doing there. Okay. Now I'm gonna have the same question. Nothing to do with Jeffrey? Correct. That was about the location of 1990.
I stand the objection.
Does this next page have anything to do with Jeffrey Williams' cell phone? No, that was a demonstrative for the location of the 1990 phone. And then this same page, same answer? Same answer. That's it. Okay, thank you. Thank you very much. Just realized I used. Okay. do you have any evidence that you can share with the jury that Jeffrey Williams, that's what I'm focused on, asked any person to go to Club Compound on April 25th, 2015 with a firearm?
I have no information in reference to that.
Do you have any evidence that on April 25, 2015, that Jeffrey Williams asked or encouraged any person to go to Club Compound at all?
I have no way of knowing that.
Do you have any evidence to share with the jury that Jeffrey Williams requested, ordered, did anything to encourage anyone to fire a weapon at a tour bus?
Again, my investigation did not include that information. It could be information unknown to me, but.
Do you have any evidence whatsoever that Jeffrey Williams knew about that tour bus shooting until the next day when he got back in jail?
Objection to the last part of the student thing.
I stand your question as the last part.
I have no way of knowing.
Ladies and gentlemen, you're to disregard the witness's last statement.
Do you have any evidence that Jeffrey Williams knew that that tour bus was shot at any time before 6 o'clock, 7 o'clock a.m. on Sunday, April 26, 2015?
Again, I have no way of knowing what was said on the phone calls or what information was passed. There's too many variables in there.
The answer is?
I don't have any information regarding that.
Okay. I'd like to use, Ms. Knight is not here. Do you remember the public post that you helped us with about the Holly Grove, I'm coming? Do you remember that?
Yes.
I need to just get the state's exhibit number because I need to have that for the jury. You don't mind? Anyone's okay with me, but single file, but I need the number also. Thanks. Your Honor, may I have just one moment?
You may, sir.
Would you be able to play part of it? Yes. Your Honor, with the court's permission, it's already in evidence, and the state's lawyer is helping me out. I appreciate it. Now, Mr. Atkins, and it's 117E. May I ask Mr. Atkins to publish that to the jury? And it's,
Yes, you may, sir.
Your Honor, it's in two different versions. He told me this is the compilation, this is the putting together.
So the whole thing you're saying?
That's what I was told. But I'm just going to refer to that one first.
It's your examination, sir.
Nice. Thank you. Okay. So the jurors have seen this, but just to refresh their memory, you found this or you were given this or somehow you came across this during your investigation, and it's two different ways, I believe. One way is just on its own, and then you found it with a blogger. That's why it's spliced together with other videos. Fair to say?
Yes.
You weren't trying to trick anybody. That's just how you found it, but you made it clear that these are separate videos.
Correct. Someone else did the compilation. Correct.
Okay. So I'm just focused on the first part of it, and I could do the time for the record, but if you could play that, if you don't mind, if you can, stop it at the end of the first one. That'd be great. And I've asked just for the first one to be played, okay?
Yes, sir.
Yeah, YSL. Carter says coming out. Friday, first show. New Orleans, Holly Grove, fuck nigga. Meet me there, better yet, beat me there, you did. With them dicks too. Yeah.
Okay, and it stopped at, and I couldn't see the time, but it stopped right at the end of the first one, Your Honor. You have the time. For 16 seconds. Your Honor, stopped at 16 seconds.
All right, sir.
I just want to ask you a couple of questions about that, okay?
Sure.
That video, if you know through your investigation, that was posted approximately a week or so. I'm not saying it has to be perfect, but approximately a week or so before the performance in Holly Grove, Louisiana at the college on Saturday evening, April 25, 2015. Does that sound accurate?
That sounds pretty accurate. It's certainly before. I don't remember the time frame. I don't know if it even gave the reference time frame. That sounds pretty accurate.
All right, well, 2 weeks. I'm not trying to.
Yeah. It was before, and yes, it was shortly before. I would agree with yes.
Okay. Did you ever seek to investigate through your investigation anybody with Jeffrey's management, like Amina Diop, remember using her name?
Yes.
Whether anybody authorized or told Jeffrey he needs to do that video. Did you do any of that type of work?
No, I have no idea who authorized or told me to do that video.
Did you ever do a part of your investigation to try to speak with somebody in Jeffrey's management as to why that video was made, video audio posting was made?
No.
Did you do any type of effort or research or attempt to learn about promotion for musicians, specifically rap artists?
Did I research how they do promotions?
Yeah, did you talk to any experts? Did you go to any business people in that industry? Did you do that as part of this investigation?
No.
Did you ever do any type of research about artists assisting themselves with promotion of their brand and getting into what they call rap battles? Did you ever do that?
Did I conduct formal research? No.
Did you ever speak with the artist, the incomparable artist known as Lil Wayne, Dwayne Carter, about this video?
Did I ever interview Dwayne Carter? No.
Did you ever interview him at all?
No.
Now, when you, I'm moving on now. I'm moving to another section. It's approximately within a couple of hours or an hour maybe after the 911 call that you arrive at the scene at the hotel in Buckhead.
About an hour and a half later, yes. Something like that.
I'm sorry, I didn't mean
Yeah,
to-
something like that. Hour and a half, hour, something like that.
And at that hotel, you were able to speak with the security manager, law enforcement officers, Mr. Lewis, and I'm not crime scene people. I'm not trying to stop the people, but you did not speak with the artist Lil Wayne or Dwayne Carter. Is that true?
That's true. He had left the scene and went into the hotel prior to my arrival.
Did you knock? And when I say you, it can be your teammates. Did you knock on the door to ask him to speak with you, or did your teammates, if you know?
No, I spoke with the security manager in reference to that, and I was advised that he didn't want to speak with me.
Okay. You have ways, when I say you, law enforcement has ways of like you got these records of subpoenaing people, or the district attorney's office can subpoena to the grand jury. Are you aware of that?
So, yeah, I don't control.
Was Mr. Dwayne Carter, to your knowledge, ever subpoenaed to come and testify at any type of hearing?
Objection, Your Honor, relevance.
I stand objection.
May I respond?
Stand objection. Move on.
Okay, all right. Do you know if today Dwayne Carter is living in America, if you know?
Yeah, I don't know that.
All right. Are you aware through your investigation whether Jeffrey and the artist known as Lil Wayne, Dwayne Carter, did and do music together?
Objection, seeing that's not evidence.
I stand objection. You rephrase it.
Okay, I'm going to rephrase it based upon your investigation. Do you have any information, and did you look for any information that Jeffrey Williams and the artist known as Lil Wayne, Dwayne Carter, do music together?
Like, have historically in the past at any time or at this time of this incident?
Let's do any time, and then we can narrow it down.
So I know as of recently, there's been music that they've done together, but at the time of this incident back then, I'm not aware of any doing music together at that point in time.
Okay. Did you do a deep dive on that? I'm not questioning your investigation, or did you do a deep dive on that?
No, like I've listened to their music, I've looked at their albums, but like a deep historical dive, if they've ever been in like a studio together, I wouldn't be able to tell you that.
Now, when you looked at their albums together, did you know on the album cover there's a snake and a goat? Do you know what I'm referring to? The Lil Wayne and Young Thug album has a symbol of a snake and a goat.
It's evidence.
I stand objection.
Did you see the album cover that you were just referring to?
I never bought like the CD. I listened to like on iTunes or something like a streaming service. I never bought the physical disc.
Okay. Did you see on your iTunes when you watch it whether the album artwork was there?
It probably was. It probably was, but I can't tell you right now.
Is there, if I show you something with the court's permission, I'm going to try to refresh your memory, okay?
Objection, Your Honor, improper. Said he does not know.
I stand objection.
If I showed you the album cover, could it possibly refresh your memory?
Yeah, I mean, if you showed me something.
Your Honor, may I have 1 second?
Yes.
Your Honor, Mr. Kokomo approached the stadium, and did you receive the court's permission?
Yes.
Sorry. Two 21C.
Hold on. Which exhibit are you showing?
Jeffrey Williams, number 221C, Your Honor.
I say, have you seen that?
I think he's doing it before, so refresh it.
Have you seen it?
Yes, I have.
Okay, all right. Mr. Kokomo, you come close.
Okay.
Did that refresh your memory, the 221C?
No, that I've never seen that before.
Okay. Thank you, sir. I noticed that you put into evidence certain Instagram, you did an Instagram return on Jeffrey's account, fair to say?
Yes,
And that's the Thugger account. I'm going by my memory, but I think that's right.
that is right.
You also did a Twitter subpoena to obtain all the Twitter records. Is that fair to say?
Yes, I think I did, yes.
And you received those too?
Yes,
And have you reviewed those?
not recently, no. But at the time, I would have reviewed it, but not recently.
Okay. Let me see if I could show you something, okay?
Yes, sir.
Your Honor, may I just step away?
Yes, sir.
Your Honor, may I have Mr. Kokomo approach again?
Yes.
He'll just show, he's gonna look at all. Yep. I need to find the return from Mr. Nard,
Yes, sir.
and then we'll come back to it. Okay. Through your investigation in 2015, the 9 months, is it fair to say that you learned that Jeffrey Williams, through your investigation, was on tour in 2015,
I think that's accurate, yes.
both in America and in Europe? Is that fair to say?
I think I do recall that, yes.
Okay. Now, you mentioned to the jury that YSL functions as a criminal street gang, these are my words, criminal street gang, as well as a lawful musical entertainment business, something to that effect. Is that fair?
That'd be fair.
And you mentioned earlier the name Walter Murphy. Remember that?
I remember the name, yes.
Okay. Now, how much contact, personal, cell phone, social media, whatever, through your investigation, did Jeffrey Williams have with Walter Murphy in 2014?
15?
What did I say?
You said 14.
15.
I know the name came up in the investigation. I can't tell you that there was the amount of contact. It certainly wasn't a focus of the investigation.
How about Trontavious Stevens?
I don't think that had, the name might have came up, but it wasn't a focus of the investigation.
I'll give you another name, okay?
Okay.
Tick.
Yeah, again, I don't think that one was the focus of the investigation either.
Or Slug.
Slug, again, I don't think that was part of my investigation.
Okay. Okay. Let's discuss Jimmy Winfrey and Jeffrey Williams' contacts with him. We went through the cell records, fair to say?
Yes.
And I'm not going to belabor it, but you know, there was a lot of calls from Jimmy Winfrey goes unanswered that you went through. You helped us understand according to the records, right?
Yes, what we can see in the records, yes.
All right. Now, did you ever learn through your investigation how Jeffrey Williams met Jimmy Winfrey?
I don't know that.
Okay. Did you ever learn through your investigation that Jimmy Winfrey is associated with Brian Williams, a performer known as Birdman, or an entertainer, I should say, known as Birdman?
That Jimmy Winfrey is associated with him?
Yeah.
I do know that there was association, yes.
And in fact, shortly after the 911 call goes out, Jimmy Winfrey's phone is connecting with Brian Williams' phone. Fair to say?
Brian Williams has a call that goes to incoming to Jimmy Winfrey after the incident, yes.
They speak, I forget the number, but 9 minutes.
8.5 minutes, 9 minutes, yes, something like that.
And you told the jurors that when you took out the warrant and it was supposed to be under seal, but somehow, I'm not suggesting how, but somehow got leaked, you found out through your investigation that Jimmy Winfrey was actually in Miami, Florida.
That's correct. I think it was like Urban Week or some celebration in Miami, Florida at that time period is my information that I have.
And you know that Brian Williams, entertainer known as Birdman, he has connection, residence, whatever you want to call it, to Miami, Florida area.
That is correct.
And then Jimmy Winfrey voluntarily turned himself into custody in Cobb County on or about the second day of, or on that Cobb County warrant, your warrant on about the second day of June 2015.
Somewhere around there, yes.
All right. Now, with regards to Bankroll Mafia, have you seen that in social posts that you helped orient the jury to?
Yes.
And you looked into what Bankroll Mafia is, fair to say?
Again, not an extensive deep dive into the organization or what it is. Only surface level that it's on Instagram and on social media.
Okay. Did you know Bankroll Mafia to be any type of business? When I say business, I'm talking about a lawful business.
Yeah, I don't know if it's incorporated or LLC. I don't know that.
Did you know that Bankroll Mafia was a musical group through your investigation?
I mean, I know they would say it during like music, or it would be on clothing during music, but yeah, beyond that, I don't know.
Did you know through your investigation that Bankroll Mafia had artists, you know who Clifford Harris is, T.I.?
I know T.I. I've heard of that. Yep. Or him, the performer.
It goes to Bankroll Mafia that has been played. It goes to the entity Bankroll Mafia and what it is. The state has shown multiple exhibits with pound Bankroll Mafia. I asked the court to reconsider its ruling.
I'll rule the objection. You can ask the question.
Thank you. He's a well-known, accomplished artist, musical artist.
T.I., I guess his real name's Clifford Harris.
Yes, sir.
Yes.
Did you know he was a member of the musical group Bankroll Mafia?
I don't know that.
Did you know that, you ever hear of Outkast?
I've heard of Outkast.
You know that Outkast was a member?
I'll sustain that objection, so it's far beyond what you wanted to ask.
Did you know that Jeffrey Williams was a member of the musical group Bankroll Mafia?
I don't know that.
Did you know that Bankroll Mafia put out an album based upon work in 2014, 15, and 16?
I don't know that.
Did you know that it was very popular, that music?
Sustain the objection.
Through your investigation, did you know that it was very popular music?
I sustain the objection.
Did you know that Jimmy Winfrey was a member of the musical group Bankroll Mafia?
I sustain that objection.
To this day, as you sit here before this jury 9 years later, did you know any music by the group Bankroll Mafia?
Again,
I'll sustain that objection.
Did you know that Bankroll Mafia was a musical group?
I sustain the objection.
Did you know that through your investigation, did you ever consider looking up what Bankroll Mafia was?
no, it wasn't. Bankroll Mafia was not a focus of my investigation. Yeah.
Okay. Besides the music industry, do you have any evidence that Jeffrey Williams knew Jimmy Winfrey in any other manner?
I mean, besides the music industry?
Yeah, that how they met.
No, again, I don't know how they met, but outside the music industry, we have the association through the cell phones and through the investigation. But yeah, that's such a broad question. I don't know what you're trying to ask.
Let's go to the Free Roscoe campaign, if you don't mind.
Okay.
Now, this is something that Jeffrey put on his page. When I say page, he's a very popular artist in 2015. Fair to say?
I mean, I don't know what you mean by popular.
I'm sorry, go ahead.
More popular than me, but probably less popular than others. I mean, I don't know.
Lots of followers on social media.
Certainly more followers than me.
Do you remember how many followers Jeffrey Williams had in 2015?
I stand the objection.
Jeffrey Williams put on his page, you showed some of them, the Free Roscoe campaign, right?
That's correct.
And they were selling T-shirts
I believe that's correct.
and hats.
I believe that's correct.
How much money through your investigation was collected on behalf of this Free Roscoe campaign?
Objection, relevant.
They brought,
I stand the objection, Mr. Steele. Let's move on.
how much money from the Free Roscoe campaign went to Jimmy Winfrey?
Objection, relevant.
I think it's relevant to the way the state brought it up, Your Honor. It played an entire recorded jail call about.
I'll overrule the objection. You can answer that, sir, if you can.
I have no idea. I didn't investigate how much money was raised by a campaign. I have no idea.
Do you know whether a penny, I'm just saying any money, went to Jimmy Winfrey or his family from the Free Roscoe campaign?
From the Free Roscoe campaign, I have no idea about that specific campaign.
Okay. I'd like to talk with you about Jimmy Winfrey being incarcerated in the Cobb County Jail.
Okay.
And the use of the phones, okay?
Okay.
So if you know, did you collect hundreds, if not more than 1,000 jail calls involving Jimmy Winfrey's?
There's certainly a lot of jail phone calls. Yes, sir.
He's on the phone a lot, fair to say?
I would agree with that.
Okay. And a total, tell the ladies and gentlemen, total, how many times through your investigation he has spoken with Jeffrey Williams?
I don't know the total because I can't tell you I've listened to every single phone call. I know that I identified a handful, a couple of them that I know basically for a fact or with certainty that they spoke, but I can't give you an exact number of the hundreds of phone calls.
Okay. Would it be fair to say that the total is 4 or less?
Objection, assume effects on evidence.
I'm
I
asking
stand
a
the
question.
objection.
Through your investigation and your work and your focus, as well as your coworkers on this case, the jail calls from Jimmy Winfrey that are recorded involve the voice of Jeffrey Williams.
Again, I didn't listen to every second of the, as you said, possibly thousands of phone calls. It'd be impossible for me to do that, so I can't give you a definitive answer. But I did identify phone calls that we did find relevant, or I did find relevant at the time.
4 or less with Jeffrey Williams?
Something like that, yes. I only bookmarked, like, I'd say probably 25 or less phone calls out of the total body.
Okay.
But again, I can't tell you that I've listened to every single phone call.
All right. Let's talk about these phone calls. You played, and when I say you played, you helped play, you were the witness that it was played through.
Yes.
And if some of these dates are wrong, please correct me because I may have converted the time wrong. But June 5, 2015, you remember that call, approximately 8:40 in the evening?
I do remember we had a June 5th call. I don't remember the exact content, but yes.
And if you need to hear it, it's in evidence, so it's not a
You're
problem.
fine, sir.
Okay. And this is approximately, if it's June 5th, 3 days after Jimmy Winfrey turned himself into custody, fair to say?
Fair to say.
And do you remember Jimmy Winfrey is speaking with his aunt or auntie?
There was a phone call with her, yes.
And it's about a car, and the car must be returned, the car must be moved from the studio. You remember all that? The jurors heard the call.
I do.
Okay. What evidence do you have that Jeffrey Williams knew about that phone conversation or the topic of that conversation?
For that specific phone call, I don't know that he did.
Okay. And on that phone call, that has nothing to do, as far as the phone call itself, with Jeffrey Williams. Is that a fair statement?
That's correct. I have no way of knowing if he had knowledge or had anything to do with it.
All right. The June 6, 2015, again, my times may be wrong, 5:11 in the afternoon, so correct me. Do you remember a discussion, Jimmy Winfrey's recorded call that was played for the jury, dealing with an OJ?
Say that one time. Oh,
Dealing with OJ, remember that?
I do remember the name OJ, yes.
And that that same call, the vehicle has to be put from Uncle Paul's name into Jimmy Winfrey's name. Do you remember that?
I do remember OJ. I do remember a discussion about the uncle, yes.
Okay. Nothing to do in that call with Jeffrey, fair.
I have no way of knowing.
But from what we heard in court, is that a true statement?
Correct, from what we heard, the snippet in court, correct.
All right. June 6th, the same day, 7:58 p.m. There's a discussion about people in the jail, and they have tattoos and YSL tattoos on their body. And do you remember that conversation?
I do remember that conversation, yes.
Okay. And there's all slimes in the jail, all YSL in the jail. Remember Jimmy Winfrey was saying that?
Yes, I
To the
do.
jury? Okay. Do you have any evidence that Jeffrey Williams knew any of those inmates in the jail?
I don't know how I would know that. I don't know the total jail population. I don't know the names. That'd be impossible for me to say.
The June 6, 2015, 10:13 p.m. call that the jurors heard, that's about the car, and the car is now in the garage, and I believe he's speaking with his auntie and someone named Rashard, I think you said.
Yeah, it was Shad or Rashad,
Rashad.
something like that, yeah.
Okay. And that's, after hearing that, that's how you got the search warrant to go to the house,
Correct,
and you seized the vehicle.
that's correct,
Okay, and when I say the vehicle, the white Camaro.
yes.
Then was played October 22, 2015, 9:33 p.m. jail call, and that's about once released, I'm not quoting, by the way, once released, there's $250,000 in a Porsche. You remember that?
I do.
And that was made on someone else's PIN, someone else's phone code.
That's correct.
And I think you said that you don't have any evidence that Mr. Winfrey received any of a valuable $250,000 or Porsche. Is that true?
Correct, I have no way of knowing.
Okay. And that phone call doesn't mention Jeffrey, does it?
Not specifically, no.
Okay.
We only have the reference, my boy ain't changed.
Okay. Then we have a June 13, 2015 phone call. That is with Jeffrey Williams, 5:39. That's when we talked about at the event, the Free Roscoe event at the park. You remember that?
Yes,
Okay. Nothing about pay for my lawyer or anything like that. It was Free Roscoe campaign is really booming. These are my words. Really taking off, right?
yes, correct.
Then we have a June 28, 2015, 3:27 p.m. Amina Diab. Remember talking about her?
Yes,
And she's a manager you found out through your investigation for Jeffrey Williams,
yes, she is associated with YSL Enterprises, yes.
the musical group, as you said, or the entertainment group.
Her name is on records indicating she's associated with YSL Enterprise.
Okay.
Her name is on the Facebook, his Facebook social media, and on the cell phone returns as well.
And did you know her to be a manager for Jeffrey Williams at that time?
I believe so. I mean, she's putting stuff in her name for YSL Enterprises. So, I mean, she was listed as a registered agent for the company.
Now, if we could pull up that jail call, and if you could give me the number, if you don't mind, and help me play it, is that something you could do? Yeah, I have 3:27 in the afternoon. Maybe we don't have to replay it if the state's having a hard time. Let me ask you, if you remember, if you don't, we're going to play it. Do you remember Jimmy Winfrey asking Amina Diop if he can borrow $25,000 from you all because his uncle left him $25,000? Uncle Paul, do you remember that?
I remember he said something about needing to pay 100,000. He had 25,000. He needed someone to pay the other 25,000, and then he would get on a payment plan for the rest. I think it was something like that.
And do you remember him asking specific, can I borrow the money?
I mean, I remember he said someone needs to put up the money. I don't know about the words borrow, but to the effect of he needed the money.
We'll play it. Okay. Do you remember later in that same conversation, Jimmy Winfrey saying, if you cannot let me borrow the money, the $25,000, just let me know?
That possibly is in there, yes.
All right. We'll have to play it because it sounds like we need to hear it directly.
Yeah, there's a lot.
Okay.
It's hard to hear sometimes the words, but yes.
And then you remember Jimmy Winfrey saying, I need paperwork to make this not look like street
business.
Yeah. Remember that?
He asked for someone to put his name on some paperwork to look legitimate because he didn't want it to look like street business. I do remember that.
Through your investigation, did YSL give Mr. Winfrey any type of notation that he's an employee or anything like that?
I didn't receive anything that indicated as such.
Okay. Do you by any chance have it? I do. You're awesome. Can you give me the number? Sure. And then can you give me the times that are relevant?
Ladies and gentlemen, while they're trying to find that to play for you, Danny, you need to take a comfort break?
Yes.
How about we take 10 minutes? All right, we're gonna be recessed 10 minutes. All rise. All right, ladies and gentlemen, our jury has left us. You're in recess for 10 minutes. All right, ladies and gentlemen, please be seated. All right, thank you, sir. Sheila, continue, sir.
You know, it's already in evidence, so I'd like to play, I'm not going to play the whole thing, just a portion of State's Exhibit number 140EB. And if I could ask the Honorable Prosecutor to assist me?
Echo Bravo.
And Your Honor, that's a good point. Thank you. We're starting at 2 minutes. We're going to 3 minutes and I have 30 seconds. So a minute and a half, Your Honor, with the court's permission.
Yes, sir.
Do me a favor, Agent, just listen closely.
Yes, sir.
You know, it's hard to hear and you've listened to it a lot of times. And then just have me break it down with the jury, okay?
Yes, sir.
For the jury. Thank you.
So I'm assuming that his parents would too.
Yeah, so I gotta get the people 40 or 50 grand. He wanted 100, but I told him I gotta work out a payment plan with him. So I was gonna try to borrow 25 from y'all, and then I was gonna cause I got a little money from the insurance left that my uncle left me, and I was gonna give him the other 25 that way. Yeah, and when I was telling my nephew, that's the day they pulled me out. They made me come to PC, and you know, shit with the DA, all them people just trying to come up here and fuck with a motherfucker messing. I ain't stood none of that. So I'm just shit. But my lawyers came and see me and stuff. And the lawyer is Manny and Lauren Zimmerman Kilgore.
What's his name?
Lauren Zimmerman and Manny Aurora. And the dude
Lauren.
Clear Lauren. Yeah.
Huh?
Yeah.
Yeah, sorry. If you keep on calling my phone, it's a transfer.
Yeah, but if they can't do it, just let me know, and I just have to go my way about done with my auntie.
All right, Lawrence Zimmerman, I can see.
Okay, and Your Honor, stopped right at 330. Thank you so much. Were you able to hear that again?
Yes, sir.
All right. And is it fair to say that that is a person that you believe to be Amina Diab speaking with Mr. Jimmy Winfrey?
That sounds right.
And it's the same date as we said before, June 28, 2015?
Correct.
And did you hear Mr. Winfrey asked to borrow, I'm stressing that word, borrow, $25,000 from, it sounded like to me like you all. And if I'm wrong, just tell the jurors what you heard.
It sounded like y'all, correct?
And that the lawyer wanted 100,000, but Mr. Winfrey may have worked down to 50,000, and he has 25,000 from his uncle Paul Guthrie passing.
From insurance, correct?
And then he's asking to borrow the 25,000.
That's what it sounded like, yes.
All right. And do you have any evidence to share with the jury that $25,000 was loaned, given, anything by YSL to Jimmy Winfrey?
I had no way of knowing how money transferred.
All right. And then went to 3:30, and towards the end of that call, did you hear Mr. Winfrey say, if you cannot, these are my words, lend me the $25,000, just let me know, or something to that effect?
Yeah, he'll have to do it his way or through his aunt, something like that, but yes.
All right, thank you. I'm not so sure I have any other questions. May I just have a minute?
Yes, you may, sir.
Thank you, sir. Do you remember speaking with Mr. Jeffrey Williams?
Actually, Your Honor.
Cases.
Please, Your Honor.
You can.
Step down, sir.
Yes.
I'm just going to wait for a gentleman.
Okay, oh. Be helpful. All right, sir. Now you can start.
Thank you, sir. Okay. Thank you so much, Agent. Your Honor, thank you.
All right, sir. Any further examiners? All right, Mr. Matthews Senior, go right ahead, sir.
Agent Racy.
Yes, sir.
Good afternoon, sir. Carrington Matthews here, represent Mr. Marquavius Huey. I have a few questions for you concerning cell phones. You've spoken a lot about your knowledge of cell phone information and evidence and investigations, correct?
Sure.
Right. You've talked a lot about call detail records in terms of it gives us a lot of information in terms of when calls were made, correct?
Yes, sir.
How long the call took place, correct?
Yes, sir.
Let's kind of shift into text messages. You have knowledge concerning text messaging, correct?
Yes, sir. In reference to call detail records, yes, sir.
Can you tell the jury how long, from your experience, text messages are available to be retrieved when under a subpoena?
Are we speaking about content or are we speaking about just the fact that text messages were sent?
Let's take them in categories. Let's talk about, first of all, let's talk about the text messaging in terms of the communication, not the content, but the communication. How long does that hang around?
Depends on the subscriber.
Okay. Do you have a range in terms of from subscriber to subscriber?
So we utilize a cheat sheet that I have on my desktop computer, but it's a work product that FBI CAST has put out, but it tells you each subscriber and their duration of time in which they keep those records. It varies from some subscribers for 1 year, or it could be extended more, a handful of years. They've drawn back over the last few years because the amount of text messages sent are larger nowadays versus 20 years ago, right? So it changes, but I would say a year per company, they at least keep it about a year.
So back text messages from one device to another device, that actual communication or that print would hang around for about a year or so, correct?
And to be specific, we're talking about traditional text message utilizing service providers. We're not talking about WhatsApp or encrypted applications, but just standard text message to text message. Typically, it's at least a year. Just the fact that a text message was sent, yes.
Okay. Let's shift over to the substance or the content of a text message.
Yes.
Tell the jury how long with the content or the substance of a text message, how long would that hang around?
So it's pretty much not anymore. They used to, again, probably years ago, when I first started my law enforcement career, you were able to get a search warrant and see content. Again, it was dependent upon company and there's a million different caveats in there. But over the years, as text messages grew, text messages and the actual phone calls, people send more text messages. And so service providers stopped retaining that data. It's just too much data. There might be one company, I'd have to look at the cheat sheet, but there's one company maybe out there that retains it maybe for 3 days, and you'd have to have a preservation request in or just get lucky with a search warrant within 3 days. But that might have changed since the last time I've looked at that cheat sheet. So from the outside, sending a legal process to a service provider, you don't expect the content anymore in investigations.
Okay. If you actually, let's say you're investigating a case and you actually have a phone of interest, the contents of that particular phone, provided those contents are not deleted, they would remain in the phone. Is that correct?
So there's caveats in everything in investigations. First, you have to be able to have the physical device. Then you have to be able to access the physical device. Is it encrypted? What type of passcode? There's a million caveats in there. Is it a 4-digit passcode, a 6-digit passcode? Is it alphanumeric, 15-digit? There's a million caveats. But if you can get into the device, there's settings within your phone that you can have text message delete after 30 days. Well, are we talking about iPhones? Are we talking about Androids? There's so many caveats in there. But can you, in the perfect situation, get a phone, have the password, or be able to bypass the password, dump the text messages? Absolutely, you can do that. There's so many caveats, and we're speaking broadly, so I don't want to give an answer that locks it in, but that's only like one specific situation. But there's a lot of caveats. But yes, theoretically, you can get a cell phone,
Right.
get a tool, get an extract messages. Yes.
So if you have the password and you have the access, you should be able to have that content in that particular cell phone, right?
Again, there's a million caveats out there, so I don't want to lock in the tool, the forensic tool that's being utilized, such as Cellbrite or Axiom. They also have to have compatibility with that device. I've had it where I've gotten a search warrant, had access, but those tools aren't compatible with the cell phone. So there's inability to actually extract the data. Again, it's technology. There's a million caveats out there. But theoretically, yes, if you have access, you have the passcode, you have a legal process, it does fit, the software does fit compatibility with the forensic tool. Yes, you can plug it in, and yes, you can download that information in that scenario.
Now, in terms of tracking the cell phone as it relates to the phone's location, that obviously would play into where the tower is located in terms of where that range of where that phone's going to be located, correct?
Again, there's another caveat in there. So you have cell phone, what we call cell site, historical cell site data that tells you where the cell site is. And without going into it, a direction, an azimuth, a cell sector. But then there's also phone companies that do things called RTT, NELOS, and there's another one, I think PTT, I might be mistaking it, but RTT stands for real-time tracking. AT&T does NELOS. So, for example, NELOS, AT&T, now more modern days, they will send a ping to your phone every 15 minutes. And so that is a ping. That is not cell tower data. So today, if I were to get a search warrant on an AT&T phone, for example, ask for cell site data and ask for NELOS data, I can get both cell tower, cell sector information, and I can actually also get those 15-minute pings without cell sector. That's a ping on the device. So again, you're getting into the technology of it, but there's a lot of caveats in what we're saying.
So when you're having a conversation with your person that you're targeting, if you would, and you have their phone, you're looking through their phone, and when you know through your investigation, through maybe even a conversation with your target, that they are aware, they are located where the alleged victim claims that they were meeting, cell phone evidence is less probative, correct?
I sustain the objection.
When it comes to cell phone technology and locating phones and tracking them, you're less concerned about tracking the phone when there's no disagreement about the location of the two people, correct?
I mean, I think I know where you're going with the question. So the value of evidence can change based off of certain external information, certainly. Yeah, I would just leave it at that. The value of the evidence certainly matters upon external information. If that makes sense, that answer makes sense.
Okay. And basic good police work, if you have the phone in your possession of your target, you're going to more than likely print out those text messages if there are some. Correct?
Not necessarily. Again, every investigation is different. I don't want to comment on every investigation everywhere all the time. It depends on In my experience, I've been a patrol officer, I've been a narcotics agent, I've been a crime against persons detective, and now a special agent with the federal government. There's different types of cases, different importance of cases, the volume of cases. There's a lot of factors that go in there. So I can't, you can't box in and say you do this every time as a matter of investigative practice. I can't tell you that I do dump cell phones on every single case that I do, even as a federal agent. I don't do that on every case.
Right. But if one of your parties is telling you that, just for example, if if there's a conflict in the versions of events, you would certainly want all of the evidence that you can to, if there's a conflict in events, Agent Racy, you would want every medium of evidence that you can get your hands on in terms of cell phone technology to help clear it up in terms of whatever that conflict is, correct? Thank you, Agent Racy.
Yes, sir.
Any other examiners, defense examiners? All right, Mr. Weinstein.
Good afternoon, Your Honor. Let me just speak to the state for one moment. I'm going to need y'all's help to pull the jail calls for EB, specifically the June 6, 2015, 1958 call. Okay, and you want to queue that up to 14 minutes, I think. Thank you for your help. Good afternoon, Agent Racy.
Good afternoon, sir.
It's good to see you again.
Yes, sir.
I have a question about your testimony from this past Monday.
Yes, sir.
Do you recall on Monday listening to a jail call with Mr. Winfrey from June 6, 2015 at 1958 hours?
I remember that, yes.
And do you remember testifying that you heard someone that identified themselves as Yak, or who was called Yak, state, quote, roll out the red carpet for Roscoe, unquote?
I remember the red carpet and that, yes, yes, sir.
Okay. What I'd like to do is I'd like to play the portion of that call starting when Yak gets on the call. And I'd like you to ask me to stop when you hear roll out the red carpet for Roscoe. Okay?
Yes, sir.
Okay. Okay, one moment, please. We're going to play 140 Echo Bravo. I believe this clip we're about to play is the clip that I was looking for. If it's not, I'll stop it and we'll figure it out. Okay. Thank you.
Yeah. Yeah, Roscoe, you did what the fuck I'm saying. I ain't doing shit, man. Just holding it down. Just got upstairs with all these niggas. Yeah, I go to court on the 16th or the 17th. But my lawyer, what the lawyer say, we?
They were gonna try to get it dismissed this week.
They don't file for a motion. I was just calling, checking on your ass. What you got going, man? Tell everybody I said what they motherfucking do. Hey, man, you won't believe this shit, dude. Motherfucker got down Yak. Know that nigga got about 50 pictures of Yak and Malik on their bunk, man. Little young nigga. He got a picture with Yak. What's his name? Hey, what little buddy name, man? Little light skinned boy. He be with little Beth Simpson. The light skin. What that light skinned boy name with the dread? Peso. Yeah, Peso. Yeah, little young nigga. Yeah, we played up, man. They got the town turned. Huh? What say, bro?
You understand?
You understand? You dig what the fuck I'm saying? Hey, boy, you sure got the town on lock, kid. These folks ripping in here, boy. You hear me, man? These folks ripping. Man, no bullshit, man. These folks love that little motherfucking ass. No jump, no gotta slide. Man, they treat a nigga like the Pope in here, man. Yeah, you know, your main motherfucking man. You understand? Yeah, sure do, but oh man, the whole joint, blood out. Everybody got stars around here.
No, you know we paying the way, man.
Yeah, hey man, it's still here. These folks love your motherfucking head down here, man. No jump, no jump.
We were better for disaster. I was for disaster. You see what I'm saying? Then we ended up winning. So I was out there.
These folks know your motherfucking ass, boy. Listen, dog, the whole motherfucking joint, brother. These folks slime out. Everybody slime, bro.
He said they chicken like the Lord.
Yeah, man, for real. Hey, listen, man, everything in here slime out, boy. Everything. Man, them folks ain't going back and forth about your motherfucking ass down here.
Say, look here, man. Everything in here slime out, man.
Listen, man. A nigga got a picture of Yak, Malik, the whole motherfucking crew on one of their beds, the little nigga, little Peso. Got a picture called Yak and Malik, the big homie. They call you the real big homie.
My little homie.
Yeah. Hey, Peso!
He 100.
Yeah, the little nigga, hey, Yak, the nigga fuck with you strong. He got, the man got the wire cell on his back and everything. He turned up. These folks got the YSL in the star, in the 5-star. The man got a picture. When I seen your picture, I'm like, hell, no, this can't be yet. He like, boy, this is my phone. I ain't going. Man, listen, this Yak right here. Yo.
Can you pause it just a second?
We do. Come on, Wayne, show love.
Okay. Now, did you hear that he said, here's Yak right here?
Yes,
Okay. So it sounds like Yak is about to get on the call, correct?
presumably,
Okay.
yes.
Can you continue playing, Mr. Atkins?
I said, you wish what the hell they come out?
Shit, I ain't talking about nothing, bro. Got no really, they just got no rhyme. I got a court date for that money and the money, so shit. What about they let me have the phone? Hey, yeah.
Hey, make sure Roscoe good, man. I've been trying to get in touch with you anyway, so.
Yeah. You know, I got him, man. That's my boy, man. You know, I got him.
Well, we're gonna blow y'all nigga ass up. We'll sit right down when we get back to Roscoe.
That what's up? What is? Hey, yeah. Yeah, you got your clay yet. These folks singing y'all music, bro. It's on God, man. These folks singing the music, man. The folks beating the whole wall down from 11 to 5 in the morning, man. I ain't thinking none of that slide shit, what? The whole dorm. The whole dorm slide out. Straight up. Man, what? These folks love y'all, boy. No Jeff, no cap. Hey, I keep saying around this town, cap ain't that. You the last motherfucker I expect to see, man. Folks got a picture of your motherfucking ass on the bed, man. Yeah, man, my big brother, man. You know, he got a picture of you, Malik. I think you was at the Fountain Blue, yeah, we had that weed outfit on. The stone outfit, you had on the stone outfit. Yeah, man, nigga holding it down, nigga be out there, motherfucker, man, no time. Man, sit back for a major comeback, you did.
Okay. Did you ever hear, listening to it again? Even though you testified on Monday that you had heard Yak say, roll out the red carpet for Roscoe. Did you hear Yak say, roll out the red carpet for Roscoe right then?
On this show call, no.
You did not? Okay, thank you. I have no further questions.
Any further defense examiners? All right, any redirect from the state?
Yes, Your Honor. Agent Racy,
Yes, ma'am.
on cross-examination, Mr. Steele asked you about a phone number 504-723-5979. You recall that?
5979, yes.
And you said that it was a contact number for 504-319-2920.
Yes.
What does that mean for it to be a do you know what it means for it to be a contact number for 504-319-2920?
So it was just in the subscriber information as probably just a secondary phone number listed with the subscriber, with the provider, excuse me.
Now, do you remember when Mr. Steele asked you to look at specifically, I believe, the 1990 phone record, and I believe we said it's the sister of Mr. Williams' phone record, and see how many times that number called 3383? Do you remember that?
I do recall that.
And specifically in the month of April, there were several dates in which those two phone numbers made contact with each other. Do you remember that?
I do.
When looking at that record, if you remember, were there more calls between that number, those two numbers, on April 25th and April 26th than what occurred prior to those dates?
Yes, there was more frequency around those dates than previous to that, yes.
Okay. And on April 25th and April 26th, was that the night in which you were investigated?
That's correct.
Mr. Steele also asked you about Shannon Stillwell's phone number. Do you remember that?
I do.
And do you remember speaking about how you may have obtained those phone numbers?
Yes, that they're just listed in Cobb County RMS. I'm not, yeah.
Is there any reason why you didn't do legal process on the Shannon Stillwell phone numbers?
Well, to be able to get legal process, you have to have an investigative reason, a basis. To get a search warrant, you have to have probable cause. If I don't have information that I can use to justify either getting a subpoena or getting a search warrant, then I can't go down that investigative path. So if I don't have reason, then I'm not going to do it.
And is that why you do it?
Correct. I tried to utilize the best investigative methods that I could with the information that I had.
And did you ever try to confirm a phone number for Shannon Stillwell?
I don't think I dug deep into Shannon Stillwell's.
And why not?
I didn't have probable cause or information at that time to push me in that direction.
Do you recall when Mr. Steele asked you whether or not you had ever interviewed Dwayne Carter?
Yes.
Throughout the course of this investigation? Yes. Did you try and interview? Sure. Do you remember when Mr. Steele asked you, like throughout your investigation, if you had ever interviewed Dwayne Carter?
I do remember that.
Okay. Did you try and interview Dwayne Carter after leaving the Mandarin Hotel?
Yes, I made phone calls.
Okay. And were you successful in being able to interview him?
I was not.
And do you recall a series of questions from Mr. Steele regarding whether or not certain videos are promotional and things of that nature? Do you recall that?
I do recall that.
Did your investigation regarding the shooting on the morning of April 26th, was that a real life shooting and not a promotional video?
It was a real life shooting, yes.
Now, we spend a lot of time on phones, so I'm going to ask you some questions about phones. Some additional questions.
Yes, ma'am.
Do you recall Mr. Steele asking you a series of questions regarding going through the records of certain people's phones and seeing if certain numbers were in the records? Do you remember that?
Yes, ma'am.
Do you personally know how many phones Mr. Jeffrey Williams had on April 26, 2015?
I'll rule the objection.
I don't know how many phones Mr. Williams had.
In your investigation, did you ever look at the records for a phone number 504-975-3904?
Did I look for it or did I?
Go ahead.
Yeah, that number was in my records, yes. But I didn't investigate that number.
Did that phone number ever come up in your investigation regarding the April shooting?
No, it didn't come up. No.
And I know, looking at this board,
When you mean which board, which one are you talking about?
yes, I'm actually walking this to the board. Looking at State's Exhibit 139, Echo Alpha, do you see those last four digits, 3904? Looking at Echo Alpha, do you see 3904?
I do see it at least in one place, yes.
Okay, and where's that?
It looks like the first one on April 26, 2015.
And does the call connect on that day?
It looks like it's 0 seconds, so it likely did not connect.
Okay.
Yes, ma'am.
Now, I want you to do me a favor. Can you look at State's Exhibit 135, Echo Charlie? No, right here. State's Exhibit 135. Echo.
Give me 1 minute.
Supposed to be 134, actually.
Oh, I'm sorry. 134 Echo Charlie. Yep, thank you.
And just to confirm, is that the record ending in 1990?
It is, yes, ma'am.
Okay, can you find that call from that first call on April 22nd to 3904 number?
3904.
And it is page 1005 to 134 Echo Charlie.
Thank you, I appreciate it.
You see that number?
3904, I do.
What is the phone number that is called?
504-975-3904.
Now, on this board, which is the 139 Echo Foxtrot, do you see the 3904 number on here?
Yeah, there's an error.
Okay.
The typographical error.
Where is the typographical error?
It has a 4 there instead of a 5.
Okay. So this should be 975-3904 based on that record.
That's correct.
Okay, and when I say that record, 134 Echo Charlie.
That's correct.
All right. Did you, during the course of your investigation, did that 504-975-3904 become relevant during your investigation?
Not during my investigation, no.
I stand objection.
Now, looking at 134 Echo Charlie, are you able to see what type of phone that 1990 number had?
The Apple iPhone 6.
Okay. And we've talked about, or Mr. Steele asked you some questions about FaceTime. Do you recall that?
Yes.
Have you been trained on FaceTime calls, and if those types of calls appear in call detail records?
Yes, you wouldn't see FaceTime calls on call detail records. It's data communication versus phone call communication.
What do you mean?
Well, so these are, again, traditional phone calls. That's what we see call detail records. FaceTime utilizes data. It doesn't utilize like the traditional cell phone network. So we're not going to see communications between phones touching through these records. It would just show up as data to the company.
Okay. Now, are you able to do a search warrant and get like what FaceTime calls are made from one phone to the next?
You'd have to have the device. I would imagine you'd have to have the device and actually get a search warrant on the device to see FaceTime data. You wouldn't be able to serve, to my knowledge, like AT&T and be able to say that phone was using FaceTime at this time.
Why is that?
I just don't think it's data communication versus like a cell phone log communication. It'd be like trying to get a search warrant from AT&T to say what internet searches the person did. I don't think they retain that data like that, at least not to my knowledge and training I've had.
So in order to see the FaceTime communication, you would need.
Your Honor, I stand objection.
Would you need the actual phone in order to see if someone is FaceTiming another phone?
To my knowledge, yes, that's correct.
With Dolly's, with the phone number associated with Dolly, did you ever have the physical phone?
No, I did not.
What about the phone associated with Duke? Did you ever have the physical phone?
No.
What about the phone with Winfrey? Did you ever have the physical phone?
No.
What about the 8553 phone? Did you ever have the physical phone?
No.
What about the Birdman phone? Did you ever have the physical phone?
No.
At this time, do you know if, from your investigation, if the Jeffrey Williams 8553 number called any of those people via FaceTime?
I have no knowledge of that, no.
What about the Duke phone? Do you know if Duke called any of those people via FaceTime?
Again, I have no knowledge of that.
The Dolly phone, same question.
Same answer.
The Cash Money Birdman phone, same question.
Same answer, ma'am.
What about things like WhatsApp, Signal, all these other ability to call people that's not the traditional way? Are you able to get records for that?
Again, so each one is different. Some of those are end-to-end encrypted. Some of those you'd have to have the actual physical phone device. Some of those service providers are overseas. So even serving legal process on them wouldn't work because they don't honor American legal process. So there's a lot of caveats in there, kind of like previous answers. But yes, generally speaking, you'd have to have the actual phone in order to extract that data.
Can you tell, looking at the call detail records, whether Mr. Williams spoke with Jimmy Winfrey through a third party such as Duke or Dolly?
I can't tell that.
I believe Mr. Steele asked you with a line of questions regarding YSL Duke's phone communicating with the Jeffrey Williams phone. Do you remember going through?
Yes,
that line of
YSL Duke
questioning?
to Jeffrey Williams, yes.
Specifically around the time of April 25th and April 26th.
Yes,
Do you remember that video seeing them on stage together?
yes.
If two people on stage together in the same city at the same time, do you expect them to talk to each other on the phone? I withdraw. Now, do you remember a line of questioning from Mr. Steele regarding any evidence of Jeffrey Williams encouraging anybody to do something? Do you remember that line of questioning?
I do, ma'am.
As far as this investigation, what did your investigation reveal as to who had a beef with Lil Wayne?
Basis.
You're saying?
Overruled, sir. Overruled. Overruled.
The investigation revealed that the beef was between Jeffrey Williams and Dwayne Carter.
Do you remember State's Exhibit 117E, the compilation video?
Yes,
From-
yes.
In that video, is Jeffrey Williams the one that says, can't name the mixtape Carter 6 because these fuck ass niggas trying to sue? Just like some hoes, I'm a big old blood, so I'm going barter 6 on the fucking way.
I do recall that, yes.
Did your investigation reveal who had a series of albums called The Carter prior to Mr. Williams?
I am aware of who had the albums Carter before.
Who was it?
That's Dwayne Carter had the Carter series.
And did your investigation reveal if Lil Wayne at this time of your investigation was in litigation regarding his album, The Carter, or the name of his album?
I am aware of litigation in regarding the Carter 6 album, yes.
In the midst of this beef between Lil Wayne and Jeffrey Williams, were the associates of Jeffrey Williams, based on your investigation, at Club Compound the night of April 25th into April 26th?
I stand the objection.
Were there individuals in the course of your investigation who had made contact with Jeffrey Williams via the telephone at the Club Compound on the night of April 25th and April 26th?
No one made contact with his telephone, so
That's
that's a proper question.
fine, I'll rephrase.
Oh, yeah, I'll stand the objection, you can rephrase.
Were there phone numbers of individuals, i.e. Jimmy Winfrey, contacting a phone number of a YSL associate's phone that was in Baton Rouge at any time? Did you see contact or Dolly's phone contacting the 8553 phone or any of those individuals at the compound on April 25th through April 26th?
No, I object, sir.
I stand as the form of the question's compound, you can break it.
Sure. Throughout your investigation, interviews, phone records, your entire investigation, not just the phone, did it reveal that people who were associated with Jeffrey Williams was at the compound on April 25th and April 26th? Your entire investigation.
Same objections before about associates.
I'm gonna overrule the objection, Mr. Steele.
Confrontation clause.
Overruled, sir.
Yes.
And were there individuals, phone numbers of individuals associated with Jeffrey Williams, their phones pinging off towers, following the same direction of the bus as it was traveling back to the hotel on the morning of April 26th?
I object.
Basis.
Questions.
What's the basis of objection, sir?
Unless guilt by association.
That's not an objection, sir. I'll overrule. If you got a proper objection I could pose, I'll listen to it. Mr. Sharp? I'll sustain as to vague. You can rephrase.
The phone number associated with 1990, is that one of the Greer sisters?
Yes,
Is that individual, based on your investigation, the sister of Jeffrey Williams?
yes,
Okay. Is that phone pinging off towers following the bus going back to the hotel?
Oral, sir.
yes, it's pinging along the same route.
Is the phone that's associated with Jimmy Winfrey the same Jimmy Winfrey he was on a phone with, on a jail call with Mr. Williams? Is that phone pinging in the same direction of the bus going back towards their hotel?
Yes,
Directions of pinging in the direction of the bus.
Oral, sir.
yes,
Is the 1990 phone, which is associated with one of Mr. Winfrey's sisters, and the phone number associated with Jimmy Winfrey, the person that he talked to on the jail call, calling each other before and after the shooting at around 3:14?
yes,
And when those calls are made, are they in the same area based on your investigation where the bus is located at the time the bus is shot?
yes, during that window of time, yes, that we're speaking about, yes.
And after the 911 call is made, are there phone calls, at least an attempted phone call, between the Dolly Greer number, the 1990 number, and the YSL Duke number after the shooting?
Objection to the form of the question.
I stand in objection.
After 3:14 a.m., is there a call between the 1990 number and the number associated with YSL Duke?
Yes,
That's not. Objection based upon the evidence presented.
That's not an objection, Mr. Steele. Overruled.
The statement of the evidence.
That's better. I still overrule it.
And is based on the video that you saw, an individual named Duke with Jeffrey Williams in Baton Rouge, Louisiana?
yes,
And after the shooting, is the 1990 number pinging off a cell tower or hitting off of a cell tower in this general area that the Jimmy Winfrey phone is pinging off of another cell tower in the same area near the Vault Studios?
Basis. It's vague. I'll stand it.
Is the 1990 phone number pinging off a cell tower near Metropolitan Avenue after the shooting?
yes,
Is the Jimmy Winfrey phone number pinging off of a tower near Metropolitan Avenue after the shooting?
yes,
And is the Vault Studios, based on your investigation, in the metropolitan area?
off Metropolitan Parkway, yes, its address, yes.
And did you have evidence that individuals from YSL were at the Vault Studios before and after this shooting, based on your investigation? You're in the quick case.
I'm overrule the objection. Mr. Steele, do you have an objection, sir? Same basis?
No.
Okay, all right, sir. Okay.
Yes,
And for your portion in this case, were you primarily focused on the shooting of the Little Wayne bus?
Objection, Your Honor, leading question.
And it's been asked and answered, so.
Outside of that investigation, did you have any other involvement in this case?
Objection, yes, ma'am.
I stand in objection.
Did you have it? Did your investigation end at the conclusion of this case?
yes.
I have no further questions.
All right, before I offer recross, if any, been brought to my attention that some individuals need to take a break, so take a comfort break. So let's just be in recess for about 10 minutes, okay? All right. All rise.
Oh my goodness. I was stretching and I kicked it.
All right, ladies and gentlemen, please be seated. Okay, you're in recess for 10 minutes. Seated.
Now I should stretch, I guess.
All right. point in time? Yes.
I would like to, before the agent leaves, ask him questions about topics that would be under the rule of completeness. I heard what you said. I respect what you said. I'm not trying to get the ire of the court. I'm not saying you're upset. I'm just saying, to me, it's relevant right now. Like, for
Mr. Steele, sir, can you step outside for a second, please? Stand fast. Okay. The whole premise, Mr. Steele, is that it's self-serving at this point in time for you to be able to elicit that particular information. If and when you decide that you should call or wish to present a defense on behalf of Mr. Williams, then I will make rulings as to the rule of completeness and other grounds. It's just not presentable now. I'm not saying you can't, but I in no way want for you not to understand and for the court to impress upon you. You don't have the right, you don't have the responsibility to present anything right now. I know you told me, well, it's going to be 7 months before we get a chance to elicit this particular evidence, but the court recognizes your right at this point in time to not present anything and the burdens of states. So we've covered that in great detail a number of times. I'll give you a continuing objection on the issue, but
example, and then I will do it in writing.
so you're still going to ask me at this point in time even though we've covered the same issue at least 7 or 8 times at this point in time, because you made this point at critical junctions that you believe are important. So I'm fully aware of the issue. I really am.
Well, okay. I will put it in writing. It's just, to me, when the state, this is what I wanted to say. If I'm going too far, I'm not trying to waste your time or anyone's time. When the state says, you noticed that there was a beef, I think that's the word, between, and the answer is Lil Wayne and Young Thug or Jeffrey Williams, I believe that under the rule of completeness, I could put in a statement of Jeffrey Williams on July 15, 2015 with this detective, excuse me.
Yes, you can. And to quote a famous politician, yes, you can, but you just can't do it now. Okay?
Now, but I'm going to obviously go with it.
Okay, yes, you can, but it's just that the law doesn't provide you the ability to do that now because it's self-serving. Okay?
I'm not
It's self-serving but like I said, if you make that decision at some point in time and at the appropriate time that you wish to do so, then I will, of course, then at that point in time, permit or allow you to present that particular evidence at that point. Okay.
I understand.
Okay. All right.
I respect your rule.
Yes, sir.
I know my objections.
Yeah, it's continuing, sir, though. Okay.
Thank you.
All right. Can we call Detective or Agent Racy back? Some of our jurors. Okay. All right, thank you, Sergeant Ingram. All right. Who do we leave off with again? I'm sorry. Mr. Steele? Yes.
Hello again.
Hello again, sir.
I just want to ask you questions. The 3904 number that you referenced just now,
Yes,
I believe it was stated, I'm not saying that you said this is what I heard, that it was a 29-second call. Did you say that?
no, I believe we said it's a 0-second call.
Okay, no connection.
Unless we need to go back to the records again, but the demonstrative shows 0 seconds.
Just want to make sure. Thank you. Okay. You mentioned on your direct examination days ago that there was a lawsuit involving the performer known as Lil Wayne, Dwayne Carter. Do you remember that?
Between Dwayne Carter and Birdman,
Yeah.
Brian Williams, correct?
Yeah, Brian Williams, entertainer known as Birdman, right?
Correct.
That did not involve Jeffrey Williams, fair to say?
Correct. He wasn't a party to the lawsuit to my knowledge, correct?
Tell the ladies and gentlemen, jury, any lawsuit that you know about through your investigation that dealt with Jeffrey Williams and Mr. Dwayne Carter, performer known as Lil Wayne.
I don't know of a lawsuit between Jeffrey Williams and Dwayne Carter.
All right. I forgot earlier, I asked you about the Twitter account.
Yes.
I want to show you the return. Haley, do you have it? Your Honor, may I ask Haley to approach for one moment?
Yes.
I understand. I'm sorry, Your Honor. Hold on one second, please. May I step back?
Yes, sir.
Madam President.
Your Honor, may we approach?
Yes.
please.
Your Honor, based upon this honorable court's ruling, I will have no other questions for now, and then I would like to have the court not excuse
Okay.
the agent.
Any other examiner for recross? Any other redirect?
That conversation.
All right. Agent Racy, you are going to be subject to recall. So please don't discuss your testimony to anybody except the attorneys in this case, okay? But I am going to release you for now. We'll give you enough time if and when that should become necessary. Give you enough lead time for you to come back, okay?
Yes, Your Honor.
All right. Okay, sir. Thank you very much.
Thank you,
Don't
Your Honor.
discuss testimony to anybody except the attorneys in this case.
Yes, Your Honor.
All right. Thank you, sir. All right, ladies and gentlemen, the hour being 5:05, we worked a full day today, a full work day. So we're going to go ahead and recess for today. And if I could have you all come back for tomorrow morning, Friday at 8:30 for anticipated 9 o'clock start time, we will have an abbreviated day. We'll probably go from that time till somewhere around the noontime hour. Then we're going to recess for the day. And then consistent with the court's earlier directives, you will have some administrative days through the 28th of Memorial Day holiday, and we'll reconvene that Tuesday. Memorial Day is the 27th. We'll resume on Tuesday, the 28th. But, ladies and gentlemen, any ministerial inquiry of me at this point? Okay. All right. Let's go through our customary admonitions. Remember, leave your notepads in the basket in the back. Do not discuss this case as you go amongst yourselves or on onesies and twosies, or as you're going any place in the courthouse or transportation wise, or as you sit back there in your headquarters, the jury room. Remember, it would be a violation for you to recap, handicap, summarize, or otherwise review or anything that you have covered or heard at this point in time. Remember, you can only begin to consider this case when the court tells you it's appropriate to do so, and then I will instruct you on how you to begin that particular deliberative process. But until then, it's forbidden for you to do that. Also, remember, it would be a violation for you to go to any third-party sites to augment or otherwise add to your understanding about what you may have learned within the four walls of this courtroom. You can only consider what's been lawfully presented within this courtroom. You cannot go to any other sites or any other persons or documents to aid in your understanding. Remember, if any third party were to try and reach out to you by any means of communication, personal or otherwise, that it would be your duty to let myself and Sergeant Ingram know immediately. And remember, do not go to any third-party sites or view any news accounts or any other accounts on any medium otherwise in regards to the trial of this matter. Again, you can only consider what's been presented within this courtroom. Ladies and gentlemen, don't go by and visit the scenes that may be depicted or you may have learned about while you're in this courtroom. And ladies and gentlemen, again, thank you so much for your patience that you've given us and the patience that you'll continue to give us as we continue with this matter. Okay. So ladies and gentlemen, unless you have any other inquiry of me, we'll see you tomorrow morning for 8:30. And then we'll, like I said, we'll get started, and tomorrow should be a pretty short work day for us. All right. Okay. All right. All rise. All right, ladies and gentlemen, please be seated. Our jury has left us. Okay, tomorrow, short work day. Who do you plan on calling tomorrow, State? Do you have some relatively short witnesses?
We do.
Okay.
It will be Ms. Latner's and Officer Clinton Hayes.
Officer who?
Hayes, Hayes.
Hayes. Okay, all right.
And at the appropriate time, Your Honor, there's just two other matters I just wanted to bring to the court's attention.
Okay, given the fact that Ms. Latner's is going to rejoin us, the issue of the CAD reports, is that going to come up tomorrow?
Yes.
Potentially?
Yes.
All right. And what other issue do you have for my consideration?
So that was half of the first one, that we were entering into another series of acts, starting with January the 6th, going through January the 10th. So that's one portion of it. The second, I think most pressing portion, however, Your Honor, is the fact that we would be asking that the court release Agent Racy from the state subpoena. He is making himself available to be subpoenaed by Mr. Steele if he so chooses. But if he were to not appear, the state would not be seeking a material witness warrant, because we were not planning on calling him again. Just to make it legal and proper, we would ask that the court require, if Mr. Steele plans to call Agent Racy or if he so chooses at some point in the future, that he just put a subpoena in his hand.
Okay, I've made that decision. I'm going to go ahead and just leave him under subpoena at this point in time. Okay. But I've already stated for purposes of the record that if Mr. Steele and his client decide they wish to present a case, then the court will make him otherwise available, given the issue of his federal subpoena and availability.
Oh, and I don't think that he requires a TUI letter. He didn't require one.
Okay.
As long as he's being questioned about his Cobb County, about this case.
Yes.
He does not need a TUI letter. He does not have to, Mr. Steele or no one else has to go through those steps.
All right, so I'll leave him under the subpoena at this point in time. Now, if Mr. Steele decides he does not wish to present a case, which he can make that decision at some point in time, if that's the case, then I will release him at that point in time. Okay? All right. What else did you wish to ask me?
It was only to tell the court that we were getting into another series of acts. This was the January the 6th. And then January the 8th, these are those series of acts that we intend to introduce evidence of, and those are the ones that the CAD reports pertain to. It was just an announcement that we were entering into a different series of acts.
Can I ask the state a question about tomorrow?
Since you've already got risen and.
Yeah, I know. I'll go ahead and do it.
Do it.
Are y'all planning on introducing the booking report tomorrow on Mr. Kendrick?
Your Honor, that is a possibility, yes.
Okay.
So that would be 3 witnesses, and the third one would be Lieutenant Fowler from the Fulton County Sheriff's Office.
I'd be requesting some redactions to that booking report.
Okay.
Would you like me to put those in writing now, or you want to address them later?
Your Honor, we can speak with Mr.
Offline? Okay, great. That's fine. Thank you.
If Mr. Lawrence, if you just.
Hold on. Yes. All right. Okay, Ms. Hilton, Ms. Love, can I see the CAB reports you're looking to, they're in court, attempting to introduce tomorrow?
Yes, Your Honor, Mr. Atkins has them, and he will bring them up to the court right now.
Have they already been shown to defense counsels?
They've been provided to the defense.
Can you show them and make sure it's the same ones they have? Okay. Gentlemen and ladies, if you wish to come up and have a look at that.
I believe that they were emailed to us, could you just tell us? We sure can. So we have call for service for case number 150060294, which is 2 pages. And I'm sorry, 3 pages, and it is labeled State Exhibit 1 Tango Alpha. Call for service for incident number 150060299 is a 2-page document, and it is labeled State Exhibit 1 Tango Bravo. Call for service for incident number 150080094. It is a 2-page document as well, labeled hold on one second. Labeled 1 Yankee Alpha. Call for service for incident number 150083128 is a 2-page document as well, and it is labeled 3128 is that is labeled 62 India Sub Alpha. Call for service for incident number 150083130 is a 3-page document labeled 62 India Bravo. Call for service for incident number 150093290 is a 2-page document, which is labeled State's Exhibit 1 Yankee Bravo. State's call for service for incident number 150102106 is a 6-page document, which we have labeled State's Exhibit 2 Yankee. And I believe that exhausts the exhibit numbers.
Okay.
And
can
we,
I ask?
Wait a minute.
I'm about to tell you.
Thank you.
The email came on May 6th.
Okay, thank you.
As well as, Your Honor, we just passed out the exhibit list as well.
Can you just tell me the time? And I'm not doubting that it happened. I'm just trying to look.
It It'll be easiest if it came from Mr. Atkins. So if you search Mr. Atkins for May 6th, we've received it. But I believe it's around 4:22 p.m. You should be getting it. I believe they're passing it out right now.
May I just pass to the court, the task force?
Yes.
Thank you. I'm sure
You did. You did. Yes, I did.
Yes.
Your Honor, just one additional thing for Mr. Shard. If they've received the exhibit list, the CAD report for Exhibit 2Y or 2 Yankee will be in the Dropbox link that was provided last week on last Friday at about 5:00 p.m. Everything else will be in that email I just stated.
Thank you, Ms. Hilton.
Question of the aforementioned documents is referenced by the state from so I believe, Mr. Harvey, you indicated you want to have discussion on this, so I'll let you have the first go ahead, sir.
I assume others will make the same objections or add when I fail to include everything. My recollection was that these incidents were mentioned as course of conduct during the course of the investigation to explain perhaps the course of the investigation. I recall that everybody joined in a objection to the admission of each one of these, and it's a January 6, 2015, to January 6, 3. Third is January 8th, 2015, two of them January 8th, January 8th, then January 9th, and January 10th. I think we made objections under the old case Teague versus the state at 252 Georgia 535.
252 Georgia 535?
Yes, 534, sorry.
Sir?
The newer case is Davis versus the state at 307 Georgia 746.
307 Georgia, what, I'm sorry?
307 Georgia 746.
Okay.
The objection was course of conduct is still hearsay. The second objection was confrontation, and I'll get to both of those in a minute. But each one of these events, as I understand it, and y'all can correct me if I'm wrong, are unindicted acts to explain the course of the investigation. I believe I joined in the hearsay and confrontation objections. I also added my, hey, prejudicial spillover. This is getting way beyond anything that Mr. Nichols may be responsible for at this particular point. And if it was being admitted solely for the purpose of showing the course of investigation, but not for the truth of the matter asserted, then I asked for a 105 instruction. I don't believe that any of these can be admitted for the truth of what happened, because we don't have the right to confront any of these people. And these are testimonial statements because they're coming from individuals to law enforcement. So as to each one of these, on behalf of Mr. Nichols, I maintain my objections to each one of these non-indicted acts that were originally admitted for course of conduct over objection. And now we have additional CAD reports that are coming in that have nothing to do with Mr. Nichols. So I renew my motion for severance. I renew everything that I've said before. And if they come in, please, again, I'm asking for a 105 instruction. So help me out here, folks. That's it.
Okay, sir. So you're asking for severance and a 105, is that right?
Asking for three things.
That's what I wanted to make sure.
Yes.
Okay.
Number one, to prohibit the admission of these, especially for the truth of the matter asserted.
If they're admissible, let me just add
Yes.
that. If they're admissible, you wish the court to give a 105 instruction. What else?
And renew my motion for severance.
Okay.
Based upon prejudicial spillover for these unindicted acts coming in from 9 years ago.
Okay, all right, sir. I'll note that, and just give me a second until such time as I've been able to consider that. Okay. Before I go any further, Ms. Love, what is the state's rationale for the attempted admission of 1 Tango Alpha, 1 Tango Bravo, 1 Yankee Alpha, 62 Lima Lima Alpha, 62 Lima Lima Bravo, 1 Yankee Bravo, 2 Yankee, and 2 Yankee Alpha through Foxtrot. 2 Yankee Alpha through 2 Yankee Golf. What's the state's purpose for admitting that particular or seeking the admission of that particular evidence?
These are all events that preceded the January 10th murder of Donovan Thomas that we believe are relevant and pertinent to the case at hand. Starting back on January the 6th, there was, and we also know that information was disclosed during interviews with various people of interest during the investigation of the case that allowed law enforcement to go back to the January 6th date. At that time, there was a fight at Club Crucial, and after that fight, shots rang out, and defendants Martinez Arnold and Diamante Kendrick were stopped speeding away from the location where the fight had broken out and shots had been fired with an orange cone caught underneath their car at the time that they were stopped. They, I believe at least Mr. Kendrick ran and was subsequently apprehended. He got out of custody on the 8th. And on the 10th, when Donovan Thomas's murder occurred, there were calls made from the jail by Mr. Arnold to persons outside the jail, which who were in the presence of Mr. Kendrick on that night. The two CAD reports relating to the January 6th incident both involve a fight in progress and then subsequently a fight with a weapon. So the shooting that occurred after that was related to the fight inside. So it's not to explain the course of.
Okay, I was about to say, but what's your theory of admission for these particular records?
One, as to the admissibility of them, I would cite for the court Kamasoko, and that would be Kilo, Alpha, Mike, Uniform, Sierra, Oscar, Kilo, Oscar versus the state. 362 Georgia App, 276. And in Kamasoko, the court addresses the admissibility of CAD reports, notwithstanding the defendant's or the appellant's assertion that the trial court erred in denying his motion in limine seeking the exclusion of the police dispatch reports or CAD reports, claiming that the state had failed to establish they were admissible under any exception to the hearsay rule. The court, turning first to appellant's argument regarding hearsay, concluded that the trial court did not abuse its discretion in admitting the CAD reports into evidence at trial under the excited utterance exception. The court went on to address that the statements made during the 911 calls about officers reporting to dispatch personnel and detailed in the CAD reports were related to a startling event or condition. The offenses committed by the assailant and the statements were made moments after or in close proximity to the time of the offenses, indicating a sufficient assurance that the statements were trustworthy. With respect to relevance, the court.
So you have the 911 calls correspond to the CAD reports?
No, we have the CAD reports themselves.
Okay.
In some instances, we have 911 calls. For the murder. For the CAD reports that we have labeled and identified for the court, we have the CAD reports. The court found that the reports were relevant to show the timeline of how long it took to locate the suspect, insofar as it rebutted one of defense counsel's opening statements regarding the amount of time that had passed. The court found that the reports were relevant in demonstrating the circumstances of the offenses, specifically the existence, nature, and location of the appellant's crime spree, his flight from officers, and his eventual apprehension. In our case, Your Honor, the feud between YSL and If Gang here in Atlanta was alleged to sort of I'd argue that it reached a pinnacle with the murder of Donovan Thomas, but there were events that led up to that and events that occurred after that. And the January 6th through January 10th incidents are the events that we allege led up to that. So the CAD reports aren't meant to explain a course of conduct. They're meant to give background to the jury of a series of events that led up to another major act alleged in this indictment. So it gives context, in our opinion, it gives context to what is going on the 10th. And it's relevant for those purposes, for whatever value that the jury gives to them.
Okay. Mr. Steele?
Your Honor, so I too was going to cite to you the same case that the state cites, and it's in Division 2.
Which one is that, sir? Kamasuko?
Exactly. It's 2022. So, Your Honor,
Division 2?
it is. It's in 2, and then it goes on to A. Talks about hearsay.
Yeah, I see. I see where it says hearsay.
Yeah.
Returned Kamasuko's argument that the CAD reports are inadmissible because they
Exactly.
contain hearsay.
Exactly. And then they go through, the court goes through excited utterance, and I believe present sense impression, but definitely excited utterance.
Yes, sir.
So I also would like you to look at footnote 3 of that opinion, if you don't mind, Your Honor.
You mean Kamasuko makes no distinction between any particular statements or declarants?
Yeah.
Okay, I'm with you.
And therefore, he did not preserve the issue for the appellate court to rule on. But what I thought was interesting to our discussion is the next sentence after the Hunt, H-U-N-T decision is mentioned. It says, in addition, if you see that, Your Honor.
Yes, sir.
Although Kamasuko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were admissible because the 911 operators or other persons writing down the declarant statements did not testify at trial, therefore he abandoned it. The reason I do that is my understanding, Your Honor, is what the state is trying to do with these specific exhibits that you mentioned is, or that we mentioned earlier, is put in the actual written document, but without the 911 call, without the 911 caller. How are you, as the finder of the law, supposed to say, yeah, this is an excited utterance or a present sense impression? All you have is a document. You don't know if this was an hour after it. You don't know if the person's laughing on the other end of the phone. You don't know. We don't know anything. And that's my problem with the admission of all this. This is just a trial by a document without a witness, without even the 911 call, which 911 call don't have the witnesses, but at least you have, like you did earlier in the trial, you can say, hey, this is confrontation clause under Pitts, so this is not, this is just hearsay. So I just want to point that out to you. I don't believe that it's admissible without more context, because all it is the CAD report, as Ms. Latner has said many times, it's just another person who is filtering information from the police and from the 911 callers and going back and forth. So we really don't know.
Okay, so your specific objection is to the reports themselves.
Yeah, I mean, without the 911 calls.
What about the 911 calls themselves?
They don't have them.
Well, they've got calls in 2 Yankee Alpha through 2 Yankee Golf.
Then it's the same thing we did earlier.
I'm sorry, let me correct myself. 2 Yankee Alpha through 2 Yankee Echo. There's a series of 5 audio 911 calls.
You need to make the call. Is it admissible or not under Pitts? We went through that whole ramification, whether this is to catch somebody, and is it a crime that already
Is it a
occurred
present sense impression or not?
versus is it confrontation clause? You know, just, hey, like in Pitts, hey, he has a parole hold, it was in Pitts. He has a parole violation.
Yeah, okay, yeah, yeah, but
You got to excise that
I
out.
understand.
So that's my point is we have no witnesses here. There's zero witnesses for these events. And I don't even know how it came in, except the state, you know, argued successfully to this honorable court, hey, that goes to my investigation, but they need to bolster this some way.
Well, here's the thing with Davis, which Mr. Harvey, that's it. Yeah, that's the guy. All right, Mr. Harvey referenced to the court, which is the successor of Teague, but Davis kind of indicates to the court that by Teague, I should say, I apologize. Applying the rule in Teague, we held as error for the trial court to permit the state to elicit testimony from the investigating officer as to a conversation that officer had with a third party for the limited purpose of explaining the officer's conduct and continuing the investigation of a robbery because such information was not relevant to determine the defendant's guilt or innocence.
I've argued that, right.
However, we ultimately affirmed the defendant's conviction and they were holding it was harmless, but the court goes on in Davis to indicate that they talk about the investigatory actions need not to be explained, and in that particular case, because of the investigation was not attacked. All right. However, in terms of, and you mentioned footnote 3, that Davis also contends this testimony violates his right to confront his accusers. This argument fails for a simple reason that Lynn did not testify to the substance of what any of the more than 30 witnesses told her.
But that's where we get this. Yeah. That's exactly what I'm saying.
Yeah. So as long as they're not stating, that particular issue, or not, not admitting those to violate your confrontation clause, then that certainly would be appropriate. However, I'm going to pause on the CAD reports themselves. That's the ones 1 Tango Alpha Bravo and 1 Yankee Alpha 62 Lima Lima Alpha and 62 Lima Lima Bravo, and 1 Yankee Bravo and 2 Yankee at this point. But let me listen to the 2 Yankee Alpha through echo calls.
Thank you.
Your Honor,
Okay.
Yes, Your Honor. These are the 911 calls surrounding the Donovan Thomas murder. And Mr. Atkins is logging back into Zoom so that the court can hear them. And Your Honor, while Mr. Atkins is logging back into Zoom, if I may just take a moment to say to the court that Davis is distinguishable from what we are doing here. We're not eliciting any kind of statements from officers on the scene, from people to explain anyone's conduct, notwithstanding what has been asserted by my esteemed colleagues on the other side of the aisle. We are showing intrinsic evidence which arises from the same series of transactions as the charged offense that is necessary to complete the story of the crime.
But if I'm the defendants, I don't have the ability to cross-examine any of these folks. I don't. I mean, in terms of just the police reports themselves, not the police reports, I'm sorry, the CAD reports themselves.
And Your Honor, Kamusoko addresses that.
Where?
In the portions that I read, it would be at can cite 280 through 281, starting at paragraph 2.
She said 280?
Yes. So the site was 362 Georgia Ave, 276. So specifically, and I will give to.
I have to, I'm sorry, I found it, I have it, so, okay.
So paragraph 2, where it starts by saying, it starts by saying, Kamasoko asserts that the trial court erred.
I'm with you.
And I'm dropping down to the second sentence in that paragraph. According to Kamasoko, the CAD reports included who said what to whom and what.
Was said to the 911 operators.
Okay, yes.
The state failed to establish that the CAD reports were admissible under any exception to the hearsay rule.
Right.
And then Kamasoko also argues that the CAD reports were not relevant. So.
And then dropping down to subparagraph A, the court said.
Okay, hearsay, I'm with you.
They turned to the argument with regarding hearsay and concluded that the trial court did not abuse its discretion in admitting those reports into evidence at trial under the excited utterance exception. And we would argue as well the present sense impression.
How am I supposed to decide that based upon a police report?
In the same way that, number one, for January the
Please not
6th,
police report, CAD report.
Okay, so in the same way that.
Because I'm just gonna pick one.
Kamasoko.
I'm gonna pick 1 Tango Alpha, all right? It's a 3-page document. How am I supposed to decide other than, the only thing that I see on here that is fight in progress as part of the call information. And then on the 3rd page, it's got a CAD narrative running on Hall Street and running on Hall, then it's got running on Paul Street. But how am I supposed to be able to determine whether or not that is an excited utterance?
Or present sense impression, I would
Present sense
argue, not
impression.
excited utterance.
Present sense
Three
impression.
ways. I'm glad the court pointed to this one. 1, we will have a responding officer testifying. 2, we will have a witness further down in the trial who will talk about the fight and the incident what ensued after the fight. It's included in 2 of our witnesses, or at least 2 statements that were given to the police, recitation of what led up to the Donovan Thomas murder.
Okay. I think you're gonna need to lay a little foundation for that. If you're proffering that, then that's gonna require a little bit of foundation. So
Proffering.
that you're gonna have an officer testify about this call, like for example, on 1/6/2015.
Yes, on 1/6/2015.
If you're gonna have somebody testify about that, then certainly, 1/6/2015, these particular calls, if you're gonna have the officers testify about that issue at that point in time, and yes, I believe that they would probably be, that it would help the court in terms of those that particular theory of admissibility.
And so, if you're on, give me one moment. And Your Honor, just to
See, and the issue that Mr. Steele is distinguishing is in Kamasuko, unlike what he's objecting to now, they didn't preserve any of that particular issue for appellate review because because Kamasuko mentions in passing that whatever was said to the 911 operators was filtered through people who didn't testify at trial, and he didn't include any citation or authority or meaningful legal argument.
And Your Honor, so
these CADs were inadmissible because 911 operators or other persons writing down and declaring statements did not testify at trial. So it's helpful if you got live testimony or if you have for example, a CAD report with a 911 call, like I was able to look at last time, I can listen, and as a threshold matter, determination if it's a cited utterance or present sense impression, because I can hear it for myself. The naked paper documents don't really give me anything without any testimony. So that's what I'm saying.
Your
I
Honor,
would defer ruling on those for the time being.
so Your Honor, if I may just briefly, with respect to the naked paper, as the court has cited, if the court looks at the times of the statements that are made during the CAD report, or even the January the 6th incident, notwithstanding the fact that we intend to bring in one of the responding officers. Your Honor, specifically, some of these calls are self-initiated by an officer. And so there will not be a 911 call. There were officers who were working at Club Crucial the night that this occurred. If the court will look at the source on page 1 of State's Exhibit 1, Tango Alpha, it says source under caller information, self-initiate. So an officer has called in that there's a fight in progress at 2:48 and 42 seconds a.m.
So you're gonna have Officer Jones or Officer Pinder come in?
Those were the responding
Okay,
officers.
or is it Officer Cannon?
So, Your Honor, the state's intent was not to bring in Officer Cannon. One of the people that we have coming in is Officer Hayes, who will be testifying about the events that led to the apprehension of Mr. Kendrick. If the court looks at the words, the narrative, if you will,
As to which one?
on the same one, so State's Exhibit
One Tango Alpha?
Yes. The 2:28:42 a.m., the remarks are running on Hall Street, 20T advised S69 on backseat, 2:38 hours, Hall Street.
Mm-hmm.
And then we have at 2:55 a.m. Running Hall Street, 20T advised S69 on backseat, 2:38 hours. They then go and advise that at 2:58 a.m. that there's a tow. We have a connection with respect to the next exhibit, State's Exhibit 1 Tango Bravo, where within the report, the two are sort of linked. If the court notes that on the first page of 1 Tango Bravo, down below the CAD narrative, in the CAD narrative portion, at 2:29 and 15 a.m., there's a call that's coming through at 2517 Donnelly Hollowell Parkway. At 2:30 and 28 a.m., the narrative reads, at Club Crucial, advised 4 Black males have 2 guns outside, JA 15. First, Stocky has on all red, and this is 2:30 and 28 a.m., going on to page 2. The rest have on all red, advised they are still on. And then related, RI related number 150060294, which is the one that I read to the court just a second ago.
That's 1 Tango Alpha.
Correct, Your Honor.
Okay.
So ultimately, like I said, Mr. Kendrick and Mr. Arnold are apprehended. Officer Hayes was one of the apprehending officers, and he would be in talking about that. But aside from his testimony, Your Honor, just from reading the narrative associated with this CAD report, the court can ascertain circumstantially that these are calls, one from law enforcement officers, self-initiated calls as to State's Exhibit 1 Tango Alpha regarding the fight at Club Crucial. And subsequently, Your Honor, the information relayed to the court in 1 Tango Bravo is relayed in a tight span of time, 2:29:15, 2:29:38, 2:30:17, 2:30:28.
I don't have any issue with that. The issue that I'm trying to figure out is whether or not, what theory of admissibility will it come in under?
That it would, forgive me if I don't respond. I'm not sure exactly that I'm going to respond to the court's question, the pertinent points of the court's question, but our assertion is that this is intrinsic evidence, that these are statements of present sense impression by an officer who is calling in to the radio, to dispatch, to have units come out to Club Crucial. And in an overlapping period of time, like a minute later, the court gets a 911 call that culminated in defendant Kendrick and co-indictee Arnold being apprehended. And we have the case that we have cited for the court, Kamasoko, says that you can look to the totality of the circumstances to make that determination. Specifically in Division 2A, where they are talking about the excited utterance exception and the fact that the basis for it is that statements are given under circumstances that eliminate the possibility of fabrication, coaching, or confabulation, and that therefore circumstances surrounding the making of the statement provide sufficient assurance that the statement is trustworthy and that cross-examination would be superfluous. Whether a hearsay statement was an excited utterance is determined by the totality of the circumstances. And in this regard, and I'm at Penn site 282, the critical inquiry is whether the declarant is still in a state of excitement resulting from that event when the declaration is made. And this is just relating to the excited utterance exception. And the court goes on to say that in this case, the CAD reports detailed facts provided to dispatch personnel by the witnesses, victims, and officers attempting to apprehend the suspect responsible for several offenses in the same vicinity around the same time. The statements made during the 911 calls are by officers reporting to dispatch personnel and detailed in the CAD reports were related to a startling event or condition, the offenses committed by the assailant, and the statements were made moments after or in close proximity to the time of the offenses, indicating a sufficient assurance that the statements were trustworthy. In this particular case, Your Honor, the statements or the commentary that was made regarding the fights, the fact that a call was initiated regarding the fights, and the fact that defendant Kendrick and defendant co-indictee Arnold are apprehended, we would argue that since all of this provides relevant information relating to events that preceded, these events themselves are intrinsic to count 1 in this indictment. This is Martinez, Arnold, Diamante, Kendrick. Information will come out at trial later on as well that this fight was, actually information has already come out through investigator Dennis, that the fight at Club Crucial was sort of a precipitation of other events. So there's nothing in these reports that incriminate or in some way suggest that other than the acts that they were arrested for, which we will have officers here to testify about, that either Diamante, Kendrick, or Martinez, Arnold did or precipitated or started the fight. But the fact is that a fight happened. The fact that a fight was reported by an officer and that you have this flight from the location afterwards. It could have been that Mr. Arnold and Mr. Kendrick were being chased by someone, but they are fleeing the location. And in that fleeing of the location, they're stopped by Officer Hayes as one of the officers. What they did and what happened after that, Officer Hayes is going to be able to testify about. So the preceding information regarding the calls that came in, we argue is relevant because, again, it's background, contextual, intrinsic information relating to at least one defendant specifically sitting here. And in that, because it's related to a co-indictee and a group dispute with another group, it is relevant to prove a portion of an element in count 1, a material element in count 1.
All right, I believe that our folks here need to take a comfort break. I've been asked to do that, so why don't we do that and come back, okay?
Okay.
I'll finish up.
Okay.
All right, we're in recess. All right, sorry, what about now, sir? Okay, all right.
So may I?
Ms. Love, I've had an opportunity to kind of consider this, all right? And I'm going to tell you where I am, Ms. Love. Given Davis, 307 Georgia, 746, and Kamasuko at 262 Georgia, 276, I am of the opinion that based upon our Court of Appeals' decision in this particular case, I don't believe that as written, these would be admissible under the excited utterance exception to the hearsay rule.
Your Honor,
or the present sense impression.
No, I was going to point to 24-8-8036, Your Honor.
Which is?
It is the hearsay rules exception, declaring available records of regularly conducted activity, Your Honor.
I understand that. But I can't make a determination. I mean, it's one thing about the records themselves. Ms. Latner can come in here and authenticate your records. I don't have any issue with that. The challenge is that they have inadmissible, at this point in time, things in them at this point. I can't make a determination as to whether or not they fall within any one of those exceptions. And that's what the appellate court seems to indicate to me that needs to occur. And that's what Kamasuko waived in this particular appellate opinion. He didn't preserve it. The defense has put you on notice that they're objecting to that. So and you've got confrontation clause issues. These reports are made for the purposes of prosecution. They fall squarely within Crawford for that particular reason.
Actually, Judge, they said otherwise in Kamasuko, if I may. They said that.
Well, if I can make that determination about them falling under an exception, yes. But at this point, because I can't make that determination, and I just.
And Your Honor, for CAD reports, I just point out that we normally do not have the person making the call.
Okay, and you know what? You may be able to get these in later. If you're going to have the officers testify about these particular instances, I don't know, this being 9 years ago, whether or not you're going to be able to do that. But, the defense in these particular ones has made a pretty valid objection in the court's opinion. Now, I haven't heard the 911 calls. I mean, they're a little different. I can make a determination on the admissibility of those under Kamasuko and under Davis.
There wasn't, for the first one, Your Honor, there wouldn't be a
First
911
one what?
call. State's Exhibit, I think we named it
One Tango Alpha.
It's a self-initiated call to dispatch. It's not a 911 call.
Okay, and?
And I'm saying that the court would not hear, I think, what the court is referencing in terms of whether it's urgent or not. This is a call made from an officer to get other officers out there, obviously to respond to a fight in progress.
Okay, but you don't have anybody to explain that, and it has hearsay in it. I mean, Kamasuko tells you that, the CAD reports have,
so.
Hold on. CAD reports include statements made by victims, witnesses, and officers to the 911 dispatchers. So, in this particular case, the court didn't abuse its discretion in admitting them because under the excited utterance exception. But I don't have any way to kind of do that because I can't listen to the 911 call and make that independent determination as a gatekeeper for myself. That's the challenge. When we dealt with this situation a little bit earlier, I was able to do that. And then you had somebody testify to it. So Ms. Latner's lays the foundation. Are you going to have anybody testify about 1 Tango Alpha?
Your Honor, 1 Tango Alpha is connected to 1 Tango Bravo.
Are
so
you
we
going to
will-
have somebody testify about
Yes.
1 Tango Alpha and 1 Tango Bravo?
So yes, in the same way that we have previously put up the CAD report and then brought in the information.
So you're going to have an officer come in who was a part of this particular incident on 1/6/2015?
Yes, that's
Who
what
is that?
Officer Hayes is. Clinton Hayes.
Clinton Hayes going to,
He's the
where
one
is
that-
he in, where is he listed on 1 Tango Bravo?
I don't know his number, his service number.
Wait a second, from looking at this, the primary unit was 1109 and Officer 1 and name was Graham Willis Graham. That's the officer. I don't know who unit 1109 is, but
Okay, so if you're in the middle of 1 Tango Alpha page 2, close to the bottom, I'll say the last 1/3 of the page.
okay.
At 1108 RT 16/215, 2015, 258.
On page 2 or page 3?
Page 2. The court sees Kendrick Diamante, date of birth.
Hold on 1 second. I do.
So Officer Hayes is the officer who was a part of that apprehension of.
Where is Hayes? Is he listed on this CAD report?
I don't know Hayes's number. Hayes is what I'm trying to get at, Your Honor, is that there will be an officer who will be testifying about the events of this particular incident. And that, along with the fact that this was made solely for the purpose of bringing officers out there to respond, not for the purposes, it's not testimonial because they were not making it for the purpose of in anticipation of litigation. They were making it to respond to an ongoing emergency as events by the call type and description. There's nothing in the CAD report that counters that assertion that we are making, that it's not being made in anticipation of litigation. It's being made simply to respond to this ongoing emergency. As the court can tell by what is happening after the call is made, that people are running, that they are running, and that there is an S69 on the back seat, that they're running. All of this relates to Mr. Kendrick and Mr. Arnold's apprehension. And that's what Officer Hayes was physically present during, irrespective of where his number, or if his number, and I think his number
Let me
will.
ask you something else. If he's going to testify that, why do you need the CAD report?
Because, Your Honor, the
Don't
CAD report
testify.
gives the time, it gives all the information in a business record that is kept in the ordinary course of business by the Atlanta Police Department 911 center, 911 call center. It's under 24-803, it's records of regularly conducted activity. And just pointing
Yeah,
to,
but that gives you the foundation, madam. It just does. And authenticity of the record. You still got to overcome the hearsay exception of whether or not it falls under one hearsay exception. Is it a present sense impression? Is it an excited utterance? I still have to be comfortable with that. I mean, because
Judge,
they had, because CAD reports include statements, victims, witnesses, and all that.
so we don't have any victim statements in here. We don't have any witnesses.
Well, they're hearsay, but they're hearsay. They're hearsay, but it's got to fall within an exception in order for me to omit it, okay, or not
To admit it. I know.
to admit it, okay, admit it. So, what is that? What am I looking for?
Present sense impression.
Okay, how am I supposed to determine it's a present sense impression without listening to it?
Your Honor, the court does not have, there's never any requirement that the court listens to anything to decide whether something is a present sense impression.
Well, I tell you what, if you can lay the foundation as to these two documents, the Alpha and Bravo, One Tango Alpha and Bravo, I'll certainly consider it. But
thank you, Judge. Thank you for that. And also, I would just, and I'm going to take my seat. I'd just like to point out that at the very least, if the court does not wish that we include in the reporting or in speaking to the jury information contained within the narrative portion, at the very least, the fact that the call was made in, was called in, that the 911 call or that the self-initiated call was made, and at what time and what address it was made. We would ask that in instances where the court finds that there's concern about any aspect of foundation or anything else,
well, Ms.
that the court
Latner's-
allows us to get that part in.
Customarily, Ms. Latner's, being a custodian, comes in here and she can certainly testify about what the codes are and what things are on that particular. I know we get objections to that, but
So it's the narrative.
She's the person that is qualified to testify about that. But
Okay.
But the narrative in terms of I think there's a valid objection as to unless it falls under an exception. So
okay. So, Judge, we can follow the court's instruction as relates to anything, of course, but we don't have any problem with that. I think that I think we can work with that. I think we can. Yes. So the CAD reports themselves and the call itself, the fact of the call and all of that is permissible under
you
the
can lay the foundation, I mean, to the reports themselves and the information that is contained therein, less the narrative, unless it's got some type of hearsay. If you got some type of hearsay,
okay.
A hearsay exception that this court can rule upon or consider. But
Yes,
it would seem like that,
And
Miss Latner's comes in here and she's the custodian for these particular records.
yes.
She can testify about all the codes and everything else that are on here because she's certainly qualified to do so. But the other things that are on here in terms of statements, unless they fall within an exception,
Gotcha.
I'm going to exclude those.
And Your Honor, I would also point out that we have, as the court is aware, we have considerably pared down the list of witnesses that we intended to call initially for trial. Some of them have been included in these incidents themselves. We have pared it down for that reason. It will be adding to the witness list if we were to put back in some of the people that we intentionally took out in order to facilitate the furthering along of this case
Remember what I said earlier. If that's the case, I mean, depending upon you have indicated that to the court in terms of your presentation of the case, but, you can't have it both ways. I mean, so if you believe you need to call live witnesses in order to establish these instances, that's within your call and your,
Understood.
I mean, if you
add more.
talk with your colleagues across the bar and they're willing to make some type of accommodation, that's fine, but understand they don't have to.
They don't, and we can add
if
people back
if
in.
they object to it, well, then you certainly have to,
Yep.
you have the responsibility of strict proof of, and presentation. So you'll just have to decide what you're going to do at that point in time.
Understood, Judge,
So,
and I
you
thank
know,
you for
okay.
allowing me to speak on the matter.
All right. So what about anybody else in terms of the police, the CAD reports or anything such as, I'm gonna, depending upon foundation, unless the narrative portions have some type of exception, I'm gonna have those excised out depending upon what is testified to.
Your Honor, regarding the codes, the codes, what we just said about the codes concerns me a little bit.
Sure.
Because if the state just says, well, what was the code reported on the call from APD CAD report 150060294, for example, I mean, then Ms. Latner is going to say, well, the code was this. Well, what does that mean? Oh, it means fight in progress or whatever. And it's still relaying hearsay. So, I mean.
But that's admissible because she can testify about what's in the records themselves. She's the custodian. She knows all the codes. I mean, and that's part of her language and linguistics. I mean, so so certainly that's a different basis.
Respectfully, I disagree.
And I'll note your objection for the record.
And Your Honor, I'll just point out that we talked about 1TA and 1TB.
1 Tango Alpha and 1 Tango Bravo.
Alpha, 1 Tango Beta?
Bravo. Beta's Greek alphabet.
Oh, I was.
Okay, all right.
So the state's saying that they have an officer for those two events. I am dubious of whether that they are going to have any witnesses for some of these other ones later on.
Well, that's the whole point of it is that certainly we'll just have to kind of see who they present and what they have to say.
Right. So I'm just putting it out there for Your Honor that there's going to be objections, and I think the safest course of action is to provide witnesses and present witnesses, and then figure out where we are with these CAD reports after that's done.
All right, sir. Anybody else in terms of CAD reports? Okay. All right. So subject to foundation and the court's rulings, we'll take it as is presented. What about the audio calls? The audio 911 calls.
Okay, so we are still waiting to get into Zoom, so the court can hear those.
Do you want us to email those to you?
You can't send those.
Or you're are they in a Dropbox link? In Your Honor, they're in a Dropbox link that we provided last Friday and that you were included in. But we could definitely play them tonight, but if you wanted to listen to them.
Can we get in though? So we're not in.
West of the end.
But Judge, if you want to listen to them at your leisure.
How many calls are you looking at?
There's 5 calls.
And how long are they?
2
or 5 minutes. One is.
Which one's 5 minutes?
Alpha is 5 minutes and 19 seconds. And two Yankee Bravo is 1 minute and 17 seconds. The next one, two Yankee Charlie is 1 minute and 4 seconds. The next one, two Yankee Delta is 1 minute and 18 seconds. Two Yankee Echo is 5 minutes and 37 seconds. So those two 5-minute calls are the ones that we recommend.
All right. Mr. Steele and everybody else, have you listened to the calls already? Because you were provided them last week. So you've listened to them? Okay. All right. Based upon your listening, sir, are there any things that I need to excise out?
I have to go through each one. Sorry, I have to go through each one, but yes.
In terms of,
Unidentified callers that are they're giving historical information, not information that's going on right at that moment. So I would suggest that this confrontation clause issue, things calling anyone witnesses. But I don't know who necessarily the caller is, and not on the stage witness list for some. I do believe that we need to go phone by phone or call by call.
So, Your Honor, we could, if the court would allow us to simply allow the court to hear the calls at the court's pleasure, it's, I think, easily enough addressed, first thing in the morning, because I think that the court will be able to glean from the calls, you know, at the court's leisure, what it considers testimonial, or not testimonial, but what it considers non-testimonial or testimonial. I don't think that it's necessary to play them now for the court unless you just want us to, but I think that the court can get an accurate understanding of the nature of the calls. Just, they're all trying to get.
when did you all send that?
We sent it on Friday around about 5:00 p.m. in the Dropbox link.
And we're gonna just send you the calls themselves as audio files rather than the Dropbox, and we'll send it to Your Honor and to counsels for each of them right now.
All right, why don't you do that right now?
Yes.
That would be fine. I'll listen to them and we'll,
We're doing that right as we speak. We're sending it now under the heading 911 audio. And it's showing sent. You got it?
I did. I have it.
So I think that the court
I have it.
can determine, listen to that. To make sure it was.
Where's Ingram? Sergeant Ingram?
Yes, sir.
And direct you all come tomorrow morning for 8:30. I'll take up the phone calls at that point in time. I'm going to listen to them and determine whether or not they fall within that. Mr. Steele, if you want to flag, because I know you don't sleep, so go ahead and flag what you think that I should be able to consider, so you have it, it's out per call. I'll certainly be able to list, to look at that after I've listened to it already, okay?
Yes, and I'll coordinate with everyone so you don't get different.
Okay, all right.
Probably in the morning, is that okay?
8:30.
Right, I mean, we can go out and shoot in the morning.
No, if you could do it tonight so I can see them, I'm gonna listen, the calls won't take me long to listen to. You got maybe about 15 minutes worth of calls, so I'll do that this evening. But if you have some specific objections to those particular calls, by call, if you'll flag them in terms of 2 Yankee Alpha, what are you saying should be excluded? That would be very helpful.
We'll do that. I just want to coordinate with everyone to make it easier for the floor.
If you could get that to us, that to me, as soon as possible, that would be great.
Thank you, sir.
All right.
Your Honor, may I give an administrative message or request?
Yes.
Tomorrow, I'm hoping I can be excused to deal with another matter. Mr. Voss is going to be here at 8:30. I will join shortly after that.
Okay. Mr. Stillwell, you okay with that? Okay. All right. Okay. All right. Unless there's anything else, I'll see you all in the morning at 8:30. All right, we're in recess. Chris.